Good morning, everybody. Happy Super Friday. Welcome to Courtroom Files Live. It's great to have you all here. Right up until the last possible moment, I thought for sure we were going to have to start in the Wayback Machine, but then all of a sudden, Judge Middleton turned on his feed. So let's see what's going on.
Okay.
Yeah.
Yes.
Here. This is Mr. Hernandez. I believe all of this case.
We're going to resolve those?
No, this one judge there, city and county cases, and it's gonna have to.
All right. We'll still put them in the Zoom room and explain what's going on.
Yes.
All right. All right. We are ready to begin. Everyone, thank you for your patience. We've been waiting for 21 minutes, but I think we're ready to go. Our first matter we're going to address is People versus Mucio Gomez Arias.
El primer caso que vamos a tratar es el de Lucio Gómez Larios.
Is that you, sir?
Don't ask me.
¿Es usted, señor? Yes.
The man on the screen is Pablo Bello. He is a certified court interpreter.
El señor en la pantalla, el señor Pablo Bello es el intérprete certificado.
And he's going to assist us this morning.
Y él nos va a asistir esta mañana.
We're just setting for last pre-trial.
All right. Senor Bello, do you swear or affirm to the best of your ability you interpret these matters from Spanish into English and English into Spanish?
Yes, I do, yeah.
Senor Gomez Arias, you got 2 tickets for driving without a valid operator's license.
Señora Arias, usted tiene 2 multas por manejar sin una licencia de manejo, o sea.
One ticket was written under state law.
Una de las multas fue escrita bajo las leyes del estado.
And file 24941 ST.
Es la forma número 2 ST, dice.
That happened allegedly on May 27th of 2024.
Esto sucedió el 27 de marzo del 2024.
You didn't appear for your arraignment.
No se presentó para su arraigo.
And a bench warrant issued for your arrest.
Y entonces el juez emitió una orden de arresto en contra suya.
A year later,
Un año después,
September 29th of 2025,
un año después, septiembre 25 del 2025,
you got stopped again for driving without a valid license.
lo detienen de nuevo por manejar sin una licencia de manejo
And speeding.
y por manejar exceso de velocidad.
When you came to court on that case,
¿Usted vino al tribunal para ese caso?
you got arrested on the bench warrant on the earlier case for not showing up for your arraignment.
Lo arrestaron ese día porque no se presentó al arraigo que ya tenía.
So one of these is from the city prosecutor and one is from the state prosecutor.
Una es del fiscal del estado y otra es del fiscal de la ciudad.
The city prosecutor has agreed to dismiss their case.
El fiscal de la ciudad le va a retirar los cargos que le hizo.
Which is file number 252020OT.
Ese caso es el 252020OT.
That is the second driving suspended and the speeding case.
Ese es el caso de que le suspendió la licencia y estaba usted manejando a exceso de velocidad.
In exchange for dismissing those cases,
A cambio de que le retiren esos dos casos,
you're going to plead guilty to the 2024 case of driving suspended or
Se tiene
driving
usted-
without a valid operator's license.
se tiene que declarar usted culpable de que estaba usted manejando sin licencia de manejo en el 2024.
In Michigan, driving without a valid operator's license is a misdemeanor.
En Michigan, manejar sin una licencia de manejo es un delito menor.
It is punishable by up to 90 days in jail
Se puede castigar hasta con 90 días de cárcel
and a fine of up to $100 plus costs.
y una multa máxima de $100 más gastos del tribunal.
And it carries 2 points on your driving record.
Y si tuviera usted licencia, le ponen 2 puntos en su licencia de manejo.
You are here with your lawyer, Ms. Casey Strong.
Usted está aquí con su abogada, la señorita Casey Straw.
Ms. Strong, you confirm the plea agreement?
Señorita Straw, ¿puede usted confirmar el acuerdo?
Yes, Your Honor, that's my understanding.
Sí, su señoría, eso es lo que yo entendí.
Senor Gomez Arias, anybody promise you anything to get you to plead to this charge?
Señor Gómez Arias, ¿alguien le prometió algo a cambio de que usted se declara culpable de este cargo?
Or threaten you to try to get you to plead?
¿O alguien lo amenazó para que usted se declarara culpable de este cargo?
No.
No.
You understand that by pleading to this charge, you'll be giving up all of these rights that you've signed on this advice of rights form in Spanish.
¿Usted entiende que si se declara usted culpable, usted está aceptando, está cediendo todos los derechos contenidos en ese documento, donde están todos sus derechos en escritos?
Now,
Yes.
this is actually the first of the 2 cases. This is the one from 2024.
Este es el primer caso de todos los casos que tiene, está fechado en el del 2024.
According to the ticket,
De acuerdo a
you
la...
drive a car on M66 near Jackson Road in Colon Township.
Sucedió en la carretera M66 en Jackson Road, dice el juez.
And they pulled you over for speeding and found that you had no valid license.
Lo detienen porque estaba usted manejando exceso de velocidad y se dan cuenta que no tiene usted una licencia de manejo válida.
Do you recall that day?
¿Se acuerda de ese día?
Where were you going?
¿Hacia dónde se dirigía, señor?
Al trabajo.
I was going to
And
work.
where do you work?
¿Dónde trabaja?
Hoy trabajo en construcción, pero nos vemos en otros lugares.
¿Cómo dice, señor?
Me
Keep
trabajo en un
your voice up. Speak louder.
y nos movemos en otros lugares. Cada vez que terminamos la casa, vamos a otras casas.
¿O en construcción?
Sí, pues no tenemos un trabajo estable, nos movemos a otros lugares.
Keep your voice up. Speak louder.
Y nos movemos en otros lugares. Sí, por eso no tenemos un trabajo estable, nos movemos a otros lugares.
I work in construction, fixing houses, and we move all over the place, depending where there is, where can we fix a house.
Well, you got that ticket and then you never showed up for court.
Bueno, le dieron esa multa y usted nunca se presentó en el tribunal
Until you got another ticket for the same thing, driving without a valid license.
hasta que le dieron otra multa por manejar sin licencia de manejo.
Then you ended up spending a night in jail.
Y se quedó una noche en la cárcel.
At one
Yeah.
point, you had tried to tell me, well, you did tell me that you had a valid Mexican driver's license.
Y después me dice que tiene usted una licencia válida de México.
Sí.
But
Yes.
you don't live in Mexico. You've moved here to Michigan.
Pero usted no vive en México, usted vive aquí en Michigan.
And when you move to Michigan, you need to get a Michigan driver's license.
Entonces, si está usted viviendo aquí en Michigan, tiene usted que tener una licencia del estado de Michigan.
The problem is you can't get a Michigan driver's license because you don't have lawful residency status.
El problema es de que usted no puede obtener una licencia de manejo válida porque no tiene usted un estado legal aquí en los Estados Unidos.
So you can't drive and I can't fix it.
Entonces usted no puede manejar y yo no puedo ayudarlo a solucionar su problema.
Do you understand?
¿Entendió?
Sí.
Yes.
I saw they did have someone bring you here today.
Yo vi que alguien lo trajo hoy aquí al tribunal.
The fine for this offense is $100.
La multa es de $100.
There's a $50 minimum fee that goes to the state of Michigan.
Otros $50 para el estado de Michigan.
A $75 crime victim right fee.
$75 para las víctimas de crímenes.
And a $150 attorney fee.
Y $150 para la abogada del tribunal.
You did post $100 of bond.
Usted puso una fianza de $100.
So the total fine with attorney fee and costs is $375.
Entonces, en total son $375 de multa.
You posted $100 of bond,
Pagó una fianza de $100.
which will apply to your fine.
Eso se lo vamos a descontar de sus multas.
So you owe $275.
Entonces, todo lo que debe son $275 en total.
Can you pay that today or do you need time to pay it?
¿Puede pagarlo hoy o necesita tiempo para pagar este dinero, señor?
¿Lo puedo pagar hoy?
I will pay today.
Very good.
Muy bien.
Now you can't drive anymore, you understand?
Ya no puede manejar, señor. ¿Lo entendió?
Sí, está bien.
Yes.
I'd fix it if I could, but I can't.
Yo lo ayudaría si pudiera, pero no puedo.
Sí, lo entiendo.
I understand.
All right, Ms. Strong, if you take your client out to the counter, he can pay that fine and his friend can drive him away and we'll
Do you want
all,
me to take his paperwork?
please.
Entonces ya nada más vaya con la abogada, pague la multa y eso es todo, señor.
Gracias.
Thank you.
Morning, everybody. Once again, happy Super Friday. Welcome to TCF Live. Good to have you all with me today. If you're a channel member and you did not catch the pre-show after the show, go back and take a look at that. It was humorful. I think you'll enjoy it. Slower start this morning out in Courtlandia. Judge Middleton is obviously up and running. Judge Elmore just got up and running a little bit ago, but that's about it at the moment. They'll come online, though. It just takes time. But let's hang with Judge Middleton for a while.
Está usted aquí en el tribunal.
We have several files regarding Narcisco Hernandez Hernandez.
Tenemos varios expedientes del señor Narcisco Hernández Hernández. Yes.
In file 24, 2176 and 77.
El número de expediente 2421-7677.
The defendant got charged with driving without a valid operator's license
El defendido le están imputando el cargo de que estaba manejando sin una licencia de manejo válida.
and leaving the scene of an accident.
Y se fue usted del lugar del accidente también.
Then he promptly failed to appear for his arraignment and a bench warrant issued for his arrest.
No se presentó a la audiencia de arraigo y el juez emitió una orden de arresto en su contra.
He's also charged with having no insurance for that incident.
También le están imputando el cargo de que no tenía usted seguro de su automóvil por ese incidente.
Similar to the last defendant,
Es un caso similar al del otro defendido.
the defendant got a ticket a year later for the same thing,
El otro defendido le dieron una multa por lo mismo un año después.
and that was alleged that on December 2nd of 2025,
Aquí dice que diciembre 2 del 2025
he was arrested for operating while intoxicated
lo arrestaron por manejar bajo la influencia del alcohol.
and open alcohol in a vehicle.
Y el otro cargo, tenía usted una botella, una lata de cerveza abierta ahí en el coche.
And again, driving without a valid license.
Y de nuevo, estaba usted manejando sin licencia de manejo.
You're here with your lawyer, Mr. Luke Knopfsinger,
Está usted aquí con su abogado, el señor Luke Nassenger,
and he tells me that the case has not been resolved, and he asked me to set this for a further pretrial.
el abogado me está diciendo que su caso no ha sido resuelto y está pidiendo otra audiencia para resolver el caso.
Some of these matters are charged under state statute,
Todos estos casos se resuelven bajo los estatutos del Estado
and some are charged under city ordinance.
y otros de los cargos son bajo las ordenanzas de la ciudad.
So there are two different prosecutors involved in the case.
Entonces hay dos fiscales diferentes involucrados en sus casos, señor.
Mr. Knopfsinger, is it correct that you're trying to resolve all the cases together?
Su abogado, el señor Dastenger, me dice que usted quiere resolver todos los casos juntos. ¿Es cierto?
Sí.
Yes.
And you would ask me to set this for a final pretrial to try to resolve all the cases.
Y me está usted pidiendo una preaudiencia para resolver todos los casos pendientes que tiene.
Sí.
Yes.
All right, we will set a final pretrial on a Thursday afternoon.
Muy bien, vamos a darle otra audiencia, una preaudiencia el jueves en la tarde.
I don't yet know what day that is.
No sé qué fecha es todavía.
But it will be on a Thursday afternoon at 2:00.
No sé la fecha, pero va a ser un jueves a las 2 de la tarde. Okay.
Do you still live on West Street?
¿Todavía vive usted en West Street?
Sí.
Yes.
All right. I want you to stay in contact with your lawyer. We're going to schedule a pretrial probably in March. and try to see if we can resolve all these cases at one time.
Bueno, por favor, manténgase en contacto con su abogado. Parece que la preaudiencia va a ser en marzo para resolver todos los casos pendientes que tiene.
He needs to get fingerprinted. Did he get printed?
Le tienen que sacar, le tienen que tomar sus huellas dactilares. El juez está preguntando que si ya le tomaron sus huellas dactilares.
We also need to take your fingerprints on at least one of these cases.
Tenemos que tomarle sus huellas dactilares por uno de los casos.
We'll do that right now.
Eso lo van a hacer en este momento.
All right. The court officer will come out and they'll see that your fingerprints are taken.
Ahorita se va a presentar un oficial con usted y por favor vaya con él para que le tomen sus huellas dactilares.
Caitlin, it's on the fail to stop at a personal injury accident case.
Eso es porque no se presentó a la... se fue de un lugar del accidente, dice el abogado. El juez, perdón.
Do you understand that you can't drive?
¿Entendió que no puede usted manejar, señor?
Oh, I'm sorry, Judge.
Yes.
Put that one on the top. All right, you're good to go.
Muy bien, ya está listo, señor. Ya se puede ir
This is continuing. All right, well, let him go. All right. Pablo, we had one more interpreter case.
Okay.
Rogelio Martinez Alamanza, and that case is being adjourned by stipulation. And that's file 252704ST. That case is off. So it'll probably be adjourned to March 6th. All right. All right, that finishes our morning. Hope your car's warmed up by now. I'll see you next time. Sorry you didn't get a trip to Centerville this afternoon because Jenny told me you were going to bring donuts from Yoder's.
Yes.
But I understand that case settled, so you can bring them next time, okay?
Thank you, Your Honor.
All right, thank you.
All right, bye-bye.
All right, we had a very troubling trend in 2024 and 2025 of young Mexican men being arrested for drunk driving. About a third of last year's cases were young Mexican drivers, often with an accident. And that looks like we're in the same pattern into the new year. All right, we have a number of cases up here, and I thank you for all your patience. We finished the interpreter cases, which take a long time, 3 times longer. So let's, I don't have Luke. So let's take Howard's case. Austin Zablocki. Tried to do the Montauk cases last, but we'll move ahead today. Good morning, Mr. Zablocki.
Morning.
This is file 251711OT. Mr. Zablocki and I spent a lot of time together. We're working on things, sometimes with success, sometimes not so much. This charge alleges driving suspended on August 19th of 2025. It's charged under Constantine City Ordinance. Hello, Mr. Levine.
Your Honor.
I'd like to see you before you leave. I forgot what you look like. Nice to see you in person.
I'll stop it.
Okay. He and I go all the way back to assistant prosecutors in 1980. At any rate, Mr. Zablocki, this charge is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. You've been having some ups and downs, and how are you doing these days?
Not too bad. Just working.
Where are you working?
Barlow Boats.
Which is where?
Bristol, I believe it is.
So you gotta get from Polar Road to Bristol for work?
Yep.
It's hard to do when your license is suspended.
I have a buddy of mine who works there, so he gets me back and forth.
That helps. Ms. Montag, I guess I'll defer to you. What's the status here?
Thank you, Your Honor. Mr. Bush and I have been working together to try to resolve Mr. Zablocki's case. The main goal that we're trying to work towards is Mr. Zablocki getting a driver's license. To that end, since the last time we were at court, he has made a lot of progress in terms of getting information together that will ultimately need to be submitted to the Secretary of State. He's been attending AA meetings. He has a book of meetings he's attending. Each time he goes, he writes a paragraph about what it is that he learned. He's gotten a drug screen. He's filled out the first part of this petition that needs to be submitted. The last thing that needs to be done is he needs to get an assessment. That costs some money, so there was a little bit of a hold back on that. But the hope is that now he can get an assessment, and that by the time we come back here, if Your Honor grants a final pretrial, then we will have a hearing date with the Secretary of State, and that will help Mr. Bush and I to resolve
Well,
this case.
I tried to get Mr. Zablocki an interlock in sobriety court. We had some stumbles. But Austin, I'm really pleased to see that notebook you got there. Part of the problem is you were not mature enough at that time to do what we were trying to do. I think you've grown up some, and maybe you can get this accomplished. The problem is, Montauk, this is going to take a while. So I can set a last pretrial, but we better set it out a little ways.
Well, the hope is that what I've been finding is that, because I do Secretary of State hearings as a matter of my practice. And so what I'm finding is that once we submit the documentation, it's taking about a month or two
Oh, that
to get
fast?
the hearing date. Yeah, it's not very long. So the real holdup here is the assessment. I don't think that will take more than a couple of weeks to get an assessment date set. So maybe, a month or two, I
All
think
right, I'll
would be
say
sufficient.
set at least 60 days out. Is that acceptable to you, Mr. Bush? Is that acceptable to you, Mr.
That
Bush?
is correct, Your Honor. I think this is a good resolution.
Mr. Bush has represented the village of Constantine for 50 years or more. And his philosophy, like many of the other prosecutors, is to try to help people get their license back. So Mr. Zablocki, there's some good news here. Maybe we can accomplish this. We'll set this no sooner than 60 days from today. And we'll see you on a Thursday afternoon at 2 o'clock.
Thank you.
All right. Thank you, Mr. Bush. I need Luke on a couple of these. Let's see what else I've got here. Mr. McLaughlin, let's take your case. You got just one. Nice to see you this morning. Mr. Westcomb, would you come up and have a seat?
Mr. Whitcomb?
Mr. Whitcomb, yes. Mr. Westcomb is somebody else. Thanks. All right, maybe we can go a little faster here if the judge wasn't so slow. Good morning, Rhonda.
Good morning, sir.
All right, as I indicated, we got a lot to do this morning. We ended up sort of stalling out a little bit at the beginning, but I think we can pick up the pace. Deputy Myers is here. She's ready to go. Yes? Who's Romero?
Brian.
Who's his lawyer?
And I just talked to Paul. I was like, "This is front of the street."
Yeah,
So is it okay? if I just
yeah,
let
that's
him-
fine. Well, let me see if he owes me any money.
Well, Judge racks up the next contestant. Once again, good morning, everybody. TCF Live, good to have you here. It is a slow morning out in Courtlandia at the moment. It looks like some courts are ready to maybe possibly start their day. I've got an eye on Judge Elmore, not any more or less compelling than what we have here at the moment. So we'll stick with Middleton for just a little while and then probably move on.
We had about 200 of those last year. As I mentioned, a lot of them were young Mexican men, and it's not a good trend. Operating while intoxicated is a misdemeanor for everybody here that's got that charge, punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be suspended. They indicate that on January 10th at about 3 o'clock in the morning, you got arrested for operating while intoxicated right outside of town here, M86 and Strobel Road. You're here with your attorney, Stephen McLaughlin, and he's discussed this with the prosecutor. And they've agreed to reduce this to a charge of impaired driving. Is that correct, Mr. McLaughlin?
That is correct, Your Honor.
Impaired driving is better for several different reasons, but the main reason is it allows you to keep a restricted driver's license to drive back and forth to work. Impaired driving is punishable by up to 93 days in jail and a fine of up to $300. Carries 4 points on your driving record rather than 6. You have a valid license presently. You even have a chauffeur's license. A restricted license would allow you to drive back and forth to work and in the course of work. You had a suspended license in the past, but it appears to be valid now. Do you understand?
Yes, sir.
And do you understand that by pleading to this charge, you'll be giving up all the rights here on your advice of rights?
Yes, Your Honor.
All right, let's take a look at this. 3 o'clock in the morning. January 10th was a Friday and it was Saturday morning. There's nothing in here but the ticket. Were you driving a car on M86 at Strobel? Were you going toward Three Rivers or toward Centerville?
Towards Three Rivers, Your Honor.
Where are you coming from?
I was coming from Orland. It was the night of the 1st. It was January 1st.
Oh, yeah, it wasn't the 10th. It was January 1st. So it was New Year's Eve.
Yes, sir.
How'd you end coming from Orland, going to where?
My mom lives in Orland. That's where actually I grew up at. So I had stopped out and seen my mom and a friend that lives around the block. And then I slowly started making my way back and I blew a tire at the bridge out here headed towards Three Rivers. I live in Three Rivers.
Okay. Says you live in Burrow, but now you live in Three Rivers.
I live in Three Rivers, yes, sir.
Well, that's a twisty turning way to come from Orland to Three Rivers.
It's just, it was like really snowing really bad. I just stayed on the main roads. Well, I came the back way from Orland.
Yeah, that's what I meant. All right, what were you drinking?
I had Budweiser.
What was your blood alcohol level, Mr. McLaughlin? Do you know?
It is. It's a 0.12, Your Honor.
All right, we're going to set this for what's called screening and sentencing. When we have a drinking driving case, we have to get some more information about you, about where you work. And so let's pick a date. We try to do these on Mondays, Mr. McLaughlin. Let's see what fits for you. How about Monday, March 16th at 11? Does that work for you?
Yes, Your Honor.
All right, Mr. McLaughlin, I'll have you take your client out to the counter and get the notice for that screening and sentencing date.
Okay.
And touch base with the probation department. We need to get his correct info. I think it shows he lives in Baroque.
Yes, we'll get that.
All right, thank you.
Judge, can I approach for
Yes.
seconds? Just, yeah, just don't leave.
Kevin Reingart, the prosecutors agreed to dismiss it in exchange for restitution. He's got bond sufficient to cover restitution. Is that something we can take care of internally in that?
Yeah, we'll do it. No, I would do it on the record.
No, I mean, can we?
Yeah.
Internally, we can just do it now. You can tell the clerk to do that. They'll
Yep.
take the restitution out and take care of it. Okay.
Right. Thanks.
All right, Mr. Moore, let's take your, do you have just one today?
Two, one's a civil infraction.
Actually, Your Honor, I had two.
Oh, you have another one?
Yeah, Mr. Brahms.
Oh, Mr. Barajas. Sorry about that. I got so many cases up here. Why don't we do him too while you're here? Go ahead and have a seat. Thank you. This is file number 26-530T. This is a Sturgis. Yes, ordinance case. You got charged with leaving the scene of a property damage accident. That's a misdemeanor. It's punishable by up to 90 days in jail, fine of up to $100, and it carries 2 points the way it's charged here. Your lawyer has worked out an agreement with the prosecutor where you will plead to a charge of leaving the scene of an accident with a fixture, which is something like a fence post or a fire hydrant or a sign. That doesn't carry any points. It's a 0-point offense, but it is a misdemeanor. Do you understand?
Yes.
Mr. McLaughlin, you agree that's the plea agreement?
Yes, Your Honor.
Did anybody threaten you to get you to plead to this?
No.
Promise you anything?
No.
All right, and you're giving up all the rights here on this advice of rights?
Yes.
Let's take a look here, Mr. Barajas, see if you'll record any money. All right, well, tell me what happened.
I was on my way to work and hit a patch of ice and
You hit a what?
a patch of ice.
Okay, and then what did you hit?
And then I hit mailbox.
All right, and that's probably fixture.
Yeah.
This was at 5 o'clock at night, cottage and 4th Street in Sturgis. So what did you do then? You just kept driving and went home?
I took it to a friend's house down the street. I just left her there.
Nice car, a 215 BMW. How much damage did it do to your car?
In total.
The total of your car?
Well, yeah, it did. It did. Because the insurance is a third. If it's a third of the cost of the car, then it's technically total.
There must have been some.
The parts are expensive.
We often think these are drunk driving cases that got away. But this is 5 o'clock at night, not 5 o'clock in the morning. And there's no indication of anything else. So I'm just gonna fine you $100 plus costs and the matter will be done. As I said, it doesn't carry any points. There's about 10 different ways to charge failing to stop or report an accident. And some have different. So one time I had a copy of all of them. Accidents to fixtures is 257621. Also carried, it used to carry a driver responsibility fee, which was $500 a year for 2 years. Thank God we've done away with that. All right, the fine's $100, and there's 75 and 50 in state costs, so the total is $225. Can you pay that today, or do you need time to pay it?
I need time to pay it.
Well, I'll give you 30 days. We'll make that due by
That's fine.
March 6th. Is that enough? There's instructions on how to pay with a credit card. You can pay with green cash, certified check, or money order. The court's address is on it, but all right, you're good to go.
Thank you. Thank you, Your Honor.
Thank you.
All right, friends, once again, good morning. Welcome to TCF Live. It's a Friday. It's a Super Friday. Why do we call it Super Friday here at TCF? Because we're overachievers. That's why. Anybody can have a regular Friday. Ours need to be just a tick better. So a certain Cedric Simpson just sat down to start his day. Let's see what's going on.
Great question. Haven't seen him. He's AWOL this morning.
I believe Mr. Feaster was just covering all the cases that I.
Mr. Feaster's covering everything?
I think so.
I think so.
I'd really like to get home for dinner. Okay. Well, we'll hold off on the waiver. I'll call cases that I don't need the waiver. So, and we'll wait for him. So just make sure I'm not calling a PD case. Court calls the case, People versus Nija Kahala.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Dan Garrett on behalf of Mr. Kahala stepping forward. Can you state your name, Najee?
Najee Kahala.
Thank you.
Your Honor, this is the daytime set for final settlement conference. The people are unable to proceed.
Motion to dismiss, Your Honor.
Well, Judge's feed just went dead. Not sure what that was all about. We'll see if he restarts it. In the meantime, back to, no, let's not do that. Let's go to Elmore, Judge Elmore. We'll go there, and I'll see what's going on with Judge Simpson.
Court in Missaukee County, however, I'm here in Washington County on the bench. We're going to take up two files. Each file is entitled People of the State of Michigan versus James Kerr. First case number is 22-3284FH, and the second file is 22-3285FH. Appearances begin with the prosecutor.
Thank you, Your Honor. David Denhout on behalf of the people.
Good morning, Your Honor. Bernard Jockins, appearing on behalf of the defendant. I'm appearing at the grace of the court by the Zoom application, and my client is also appearing on the Zoom application.
All right, Nancy, if you can't see that, it's Jockums, J-O-C-U-N-S. All right, folks, thank you very much. Also joining us today via Zoom from the Gladwin County Jail is the defendant, Mr. James Kerr. Mr. Kerr, are you able to see and hear the court?
Yes, I can see the courtroom.
All right, good enough. All right. Here today for a alleged bond violation, and it looks like we had an initial show cause or arraignment back on January 30th. The court ordered that the defendant would be held without bond. There was a withdrawal of counsel, Barnett, who actually hadn't appeared on the case, I don't think, in a couple of years. And then we got Mr. Jockums, who has now come on to help us today. Let me find the allegation here, just a moment. All right, looks like there was a amendment to his bond. I signed that back in June 26, 2024. Like he had been allowed to attend treatment back in 2022, then had been allegedly in an absconder status since. Mr. Jockins, how does your client wish to respond to this today? Are we going to have a contested hearing or what?
No, Your Honor, and this is what's going on today. He's going to be acknowledging responsibility of the bench warrant and the violation, and it's going to be part of a global resolution.
All right, so we anticipate a resolution today to the case, Mr. Denham?
That's correct, Your Honor.
Okay.
Your Honor, opposing counsel and myself, we've been communicating over the last 2 days, and it's my understanding that to resolve both cases, which involve the underlying narcotics found at 2 traffic stops. In any event, to resolve both cases, it's my understanding that the defendant will be pleading guilty to use of methamphetamine, that being a maximum 1-year misdemeanor. It may make sense to enter that. I have no particular preference, but it may make sense to enter that in 223284 because the underlying charge was possession of meth in that particular file. And then the other file would be dismissed. And as part of this global resolution, as opposing counsel has indicated, there will be an acknowledgement that he failed to return as required by the prior court order.
All right. So I'm just going to make sure I've got that all correct. In file 3284, the defendant is charged with possession of meth as a 3rd habitual felony offender. Both of those will be dismissed if the defendant enters a plea of guilty to the lesser charge of use, which is a misdemeanor.
Yeah, that's correct.
And then in addition to that, if that happens, then in file 3285, where the defendant has a charge of possession of an analog, operating a license suspended, operating a vehicle with an unlawful plate, as a 3rd habitual offender, that will all be dismissed.
That's correct.
All right, Mr. Jockins, is that what you understand, sir, today as well?
That's an accurate statement, Your Honor.
All right, Mr. Kerr, have you heard what the attorneys have described to me as the resolution today?
Yes, Your Honor.
All right, and is that how you wish to resolve today's case or cases?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right, well, these cases came about a few years ago. We're going to talk about the charges and the pretrial agreement in just a moment. Mr. Kerr, however, we need to go back over and talk about the bond violation allegation. Other than the terms of the pretrial agreement, which we've discussed today already on the record, have there been any other promises, threats, or inducements to get you to plead, or admit responsibility to violating the bond conditions?
No, Your Honor.
Oh, okay. Hold on, because you looked a little inquisitive there. I'm going to make sure I say it loudly enough so you can hear me. Okay. I understand that you're on a laptop. So part of today's resolution is not only the pleas, as I mentioned a moment ago, and the dismissals, but also that you're going to admit responsibility for violating your bond and being in an absconder status. Is that true?
Oh, yes, Your Honor.
Okay, thank you. Has anyone forced you to do this, compelled you to do it, put a gun to your head, threatened to beat you up or anything like that?
No, Your Honor.
All right, so you're making this choice of your own free will today, sir?
Yes, Your Honor.
All right. Therefore, I'm going to ask Mr. Kerr, is it true that you violated your bond and you've been in an absconder status now for the last couple of years?
Yes, Your Honor.
All right, thank you. All right, the court finds the defendant in violation of his bond. Technically, the court revokes his bond and remands him into custody. Next thing, Mr. Kerr, is we're going to talk about these pleas in these two cases. Are you able to hear me clearly?
Yeah.
Do I need to speak up louder?
No, they're just doing dishes or something. There's water spraying too. I can hear you pretty good.
All right, thank you. All right, sir, there are two files. The first file is file number 3284. In that case, you are charged with a single count of possession of methamphetamine. Now, that initially is a felony punishable by up to 10 years and or up to $15,000. Plus, there is a sentencing enhancement called a third habitual felony offender. And what that means is if you were convicted with that on the charge sheet, within the discretion of the court, that maximum punishment could be increased from up to 10 years to up to 20 years, and from up to $15,000 to up to $30,000. However, all of that will be dismissed today if you enter a plea of guilty to an added count 2. Added count 2 would be a charge of use of the controlled substance methamphetamine. Now, use is a misdemeanor. That is punishable by up to 1 year and or up to $1,000. You understand?
Yes, Your Honor.
All right, thank you. Now, I keep in mind here for you that if you were to be picked up and charged or convicted of some other drug case, this conviction for a use could also be used against you to increase the potential punishments on any future drug case. Now, by the way, when I say that, I'm not trying to suggest that that's going to happen to you or that you're going to go back to using controlled substances, but I just want to make sure you understand how it could impact you in the future. Do you understand so far?
Yes, Your Honor.
Now, in the other file, file 3285, you are charged with 3 criminal offenses. Count 1 is possession of a controlled substance. Specifically, it's called an analog. An analog is a controlled substance that's derived from a controlled substance, but it might be made into a medication. And this one is diazepam. Now, that's a felony punishable by up to 2 years and or up to $2,000. Plus, again, there is a third habitual felony offender enhancement. That could, within the discretion of the court, allow the court to increase that potential punishment from up to 2 years to up to 4 years, and from up to $2,000 to up to $4,000. Count 2 is operating a vehicle while your license is suspended, denied, or revoked. That's a misdemeanor punishable by up to 93 days and up to $500 plus vehicle mobilization. And count 3 is a charge of unlawful use of a plate on a vehicle. That is a misdemeanor punishable by up to 90 days and or up to $100. However, all of that will be dismissed if you enter that plea of guilty to the added count 2 of use in the other file. You understand so far?
Yes, Your Honor.
Now, by entering a plea of guilty, if this court accepts that plea, you will be waiving certain rights. Now, that includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have mental illness used against you, and the right to testify at a trial if you're to choose to testify. Do you understand those rights, Mr. Kerr?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as they apply to these particular cases?
Yes, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be then by filing an application for leave to appeal and not a claim to appeal by right, which is only entitled to a defendant when they are convicted after a trial. Or you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now on the record. Have there been any other promises, threats, or inducements to compel or encourage you to plead guilty the day that we haven't talked about?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, I understand that Mr. Jockins has come in to help you a little bit here at the end. Have you been able to speak with him about the charges?
Yes, Your Honor.
Have you been able to speak with him about the pretrial agreement?
Yes, Your Honor.
Has he been available to answer all your questions for you?
Yes, Your Honor.
And are you satisfied with his counsel thus far?
Yes, Your Honor.
All right. Now, we're going to talk here in a minute. There's we'll probably do sentencing. Well, anyways, I'll look into it. Has anybody made any promise to you or suggested to you exactly what the what the sentence would be from this court?
No, Your Honor.
All right. Do you still wish to enter the plea of guilty that we discussed earlier?
Yes, Your Honor.
In file 3284, as to the added count 2 of use of methamphetamine, a misdemeanor punishable by up to $1,000 and up to a year. How do you plead?
Guilty.
Before the court can accept that plea, I need to have you tell me what you did that makes you guilty of that offense. So I'm going to turn your attention almost 4 years ago now, 3.5 years ago, back to August 5th of 2021, over in Richland Township in Missaukee County. Were you stopped out on West Falmouth Road, looks like by a deputy?
Yes, Your Honor.
All right, and were you driving a car? Were you a passenger in a car?
I was driving.
All right, and when that officer was there, did they find some methamphetamine on your person or within your area of control?
Yes, Your Honor.
Tell me where it was.
It was like right. I was using it. It was on my lap.
Okay, and so when you said you were using it, how were you using it?
Smoking it.
Okay, and did you know that what you were inhaling or consuming was the controlled substance, methamphetamine?
Yes, Your Honor.
All right. And I always find this next question, and I don't mean to be rude, a little bit comical because technically methamphetamine, I think, is used for 2 or 3 medical issues somewhere in the world, but I don't think you have them. Did you have any lawful right to be consuming or using that controlled substance that day?
No, Your Honor.
All right, thank you. Mr. Denon, you believe the defense provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
You believe the court's in compliance with Mission Control 6.302?
I do indeed, Your Honor.
All right, Mr. Jockins, do you agree with all three of those?
Yes, Your Honor.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements for added count 2 in file 3284. Therefore, the defendant is found guilty of that count for use of the controlled substance methamphetamine. The remaining count 1, and the third habitual enhancement will be dismissed at or after the time of sentencing. At the same time, the court will dismiss the counts alleged in file 3285. Now, the next question is, can we proceed to sentencing? And what's going to help me make up my mind is, Mr. Jockins, can you tell me, is your client serving a jail sentence? Does he have another charge over in Gladwin? That'll help me make a decision.
To my understanding, Mr. Kerr is serving a sentence in which he has a cap that might be 1 year, but I believe that Mr. Kerr, if he is asked directly, he could tell the court exactly what that sentence is, Judge.
All right, thank you. Mr. Kerr, can you tell me for what are you serving a sentence? What's the conviction?
A fleeting and eluding, I have to March. March is my next court date, and I took a deal here trying to clear up all my warrants for every county and take responsibility for all my actions. And I took a deal here for 1 year cap. Just waiting on them, and my next court date is till March.
All right, thank you. So,
10th.
all right, so that means, at least I interpret what you're telling me, is that you have not yet been sentenced, but you have entered a pretrial agreement in which there is an agreement that there would be up to 1 year, or what other people will call as a 1 year or a jail cap. Is that correct?
Yes, Your Honor.
All right, thank you. Mr. Denham, any objection to proceeding to sentencing?
No objection. I would be prepared to proceed today, Your Honor.
All right. Now, Mr. Kerr, I can't proceed with sentencing in this file right now. However, before I do so, I need to ask you a question. Every defendant has the right to be in front of the court when there is a sentencing. However, you are able to waive that right and allow us to conduct sentencing right now via Zoom. Do you waive that right to be physically present, or do you want me to send somebody down to pick you up and drive you over here?
No, Your Honor, I don't want to waste the court's time. I waive that right.
All right. Mr. Jockins, any objection to that waiver?
No, Your Honor.
Thank you. I find that the technology is appropriate and permissible underneath the court rules. Mr. Denham, your recommendation on behalf of the people?
Yes, Your Honor, thank you. Your Honor, the two cases involve two separate traffic stops within a few days apart, each finding narcotics. There was nothing exacerbating about the traffic stops themselves. There was no resisting or anything. So he was cooperative at the scene, and some time has elapsed. I believe initially he left because he had a medical condition. In any event, the people are not requesting a period of probation. We believe that it would be duplicative based upon the plea that's been entered in another county. We would leave any jail term to discretion of the court, Your Honor.
Thank you. Mr. Kerr, do you still live over in Taylor, or where are you living these days?
I'm Gladwin, but I plan on moving out of state once I'm out of here because my dad just moved out of state. That's why I'm trying to serve jail time for it.
No problem. All right, I'll listen to you in just a moment. Mr. Jockins, anything in allocution?
Your Honor, this is a unique situation because usually somebody that has multiple charges and multiple warrants at the same time, a lot worse things can happen in 4 years. He absconded for 2 years. I talked to him about this yesterday, and he was scared. He was trying to get by. He was trying to make money. And, from initially, I believe that there was a medical issue, and he maybe a credit for the time that he's already been served, as he's going to be serving about another 10 months or so in the Gladwin County Jail.
Thank you, Mr. Jockins. Mr. Kerr, before the court issues a sentence, you have the right to be heard. Is there anything else you wish to say today, sir?
I would just like to say I accept responsibility for not coming back. I had spinal fusion. Even Gladwin's got me going to do a brain scan, so I got a lot of medical issues, and I'm trying to, you know, push through it and accept responsibility for my actions and my actions alone. And thank you, Your Honor.
All right, thank you. Court recognizes initially today that, hold on. This is a conviction for a misdemeanor. The law requires the court to begin with a presumption of just fines and costs, no jail and/or probation. The court, however, does find reasonable grounds to give a jail sentence. That reasonable grounds is based upon the defendant's prior criminal history that I can see here on the felony informations in both files. The fact that he has multiple cases going on at the same time. Also that he's been picked up on a flee and elude in Gladwin County. Plus the fact that we had sent him to rehab, and then that's when he absconded. The court therefore sentences the defendant in file 3284 as follows: a $50 state minimum fee, a $75 crime victims' right fund fee, a $100 court cost for the processing of the case. Mr. Jockins, again, you accepted this as an appointment, is that correct?
That's correct, Your Honor.
Court assesses a $300 attorney fee. The court also assesses a $100 fine. Because there is no supervision, the court does not obviously order any supervision fee. As for a period of jail, the court, considering that he has a gap in the other case. Well, hold on, Mr. Kerr, when did you get arrested, sir? Or, when did you get arrested?
In Gladwin?
Yes, sir.
It was 2024, an old fleeting and eluding warrant.
Yeah, but when did you get arrested? How long have you been in jail is my question.
Beginning of, it was December 27th.
Hold on just a moment. Let me take a look here.
It was like the beginning, or I've been here for, I don't even know what today is. I've been here about a month, I'd say.
All right, 1 second.
All right.
All right. The court sentences the defendant to a jail term that will run concurrent to whatever other sentence he is currently serving or about to be served. I'm sorry, ordered by the other court. That is, again, of course, if the other court complies, it's up to the judicial discretion of that judge. But the court sentences the defendant to 150 days, and so far, I am counting 26 days of credit. For the record, in case it ever comes up, I see that in this original file, 3284, the defendant was arrested on January 29th of 2022. The court allowed that he be released on February 17th of 2022. Therefore, in that year, he had 19 days, and thus far, because I conducted the arraignment on the 30th of January and up to today, that's an additional week. Therefore, that gives the defendant the 26 days. Now with good time, and I'm not, hold on, for good time, 1 second. If I'm correct, that means the defendant has 99 days left to serve on this particular file. It is the intent of this court to sentence you in a way that allows you to serve them concurrently and get out at the same time, or at least this hopefully shouldn't block you getting out. I don't know if that makes sense, but it does to me. Mr. Jockins, do you have any questions about the sentence here of the court?
No, I do not, but I would like to give my email address to the court clerk so I could get a judgment of sentence, if that's okay, Your Honor.
Yeah, go right ahead, sir.
It is my first name, Bernard, B. O as in Oscar. S as in Sierra. Yes, Your Honor.
All right. So I'm a retired lieutenant colonel. All right. Anything further today, Mr. Denham, on behalf of the people?
No, Your Honor.
Mr. Kerr, do you have any questions about the sentence today?
Well, I get like paperwork mailed on how much I owe.
Yes, sir.
All right, thank you, Your Honor. No more questions.
All right. Thank you. We're adjourned.
I hope everybody's having a wonderful Friday so far. Thank you for joining us here at TCF Live and making us part of your day. So we started with Judge Simpson a little while ago, and then all of a sudden he just went offline, but he's back. So let's go see what's going on.
All right, state your name, please, ma'am.
Renee Darga.
Thank you.
Your Honor, this is the date and time set for final settlement conference. The people are unable to proceed.
Your Honor, I would move to dismiss. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, Your Honor. Thank you. Bye, Mr. Dark. Take care. Court calls cases of the people versus John Duffine.
Morning, Your Honor. Cook for the people.
Morning, I'm Rob Jacob on behalf of Mr. Duffine, who's approaching the podium. John, take the rest.
John Duffine.
Your Honor, this is the date and time set for final settlement conference. The people are unable to proceed on either matter.
Yes, this matter be dismissed, Judge.
People being unable to proceed, these matters are dismissed. That's without prejudice.
Thank you, man. Have a nice weekend.
Thank you, Your Honor.
Thank you. I'll see you now.
Court calls case people versus Shakara Griffin.
Your Honor, Raymond Cook for the people.
Oh, these are PD cases.
Griffin? I just saw Mr. Bird. I don't know where.
Oh, that was Bird's case?
Yeah.
You're sitting down there all morning and I call your case and you're not there.
Sorry, Your Honor.
No, you're not.
Apologize. Yep. Brandon Bird on behalf of Kyra Griffin. Ms. Griffin, can you please state your full name for the record?
Kyra Griffin.
Your Honor, this is the date and time set for final settlement conference. At this time, people are unable to proceed.
Respectfully request dismissal, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
And you, Your Honorable Court, have a great Friday.
You do the same, sir.
Thank you.
Court calls case people versus Edgar Castellanos.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Julian Put on behalf of the defendant, Edgar Castellanos. Please state your name.
Edgar Castellanos.
Your Honor, this is the date time set for final settlement conference. At this time, people are unable to proceed.
And we move for dismissal.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thanks, sir.
Does call the case People versus Mackenzie Nyquist.
And said on behalf of the people, Your Honor.
Morning, Your Honor.
Uh-oh. This is gonna be long, I bet. We were on a roll. We're not.
Hi, my name is Mary Carthew. This is Matthew Actui. We are student attorneys requesting to appear on the record under MCR 8.120. Will you state your name for the record?
Mackenzie Nyquist.
You forgot one part.
Under the supervision of Ms. Sarah Sallin, and obviously Ms. Nyquist is here today in court.
Good morning, Miss Allen.
Good morning, Judge.
You guys haven't been before me before, have you?
No.
No.
We're just 3 weeks in, Judge.
Yeah, that's what I thought.
Yeah.
Where are you from?
I'm from Michigan.
Michigan, where? It's a big state.
Rochester, Oxford.
Okay. Kind of local, sort of.
Yeah, an hour and a half.
Where'd you go to undergrad?
I went to Michigan State.
She was doing good with Rochester. Michigan State on purpose.
Yeah,
Oh,
loved it.
Well, what about you? Where?
Wisconsin.
Great. Where'd you go to undergrad?
Marquette University in Milwaukee.
Okay, you went to Marquette, so you're good. Okay. Here. All right, I guess I'll give you permission to practice.
Thank you, Your Honor.
You're welcome.
Your Honor, can we approach before we do the plea?
Sure.
Okay, friends, since he's muted himself, let's head back to Judge Elmore, new contestant.
This case number 5-14153-FH. Appearances from counsel, please.
Lisa Dahl for the people.
And I'm Jeff Harrison. I'm here on behalf of Devin Jean Plum.
All right, thank you. Ms. Plum joins us this morning from Wexford County Jail via Zoom. Ms. Plum, are you able to see and hear the court today?
Yes, I am, Your Honor.
Thank you. We are here today for a motion filed by the defense regarding a modification of bond. The court has received and reviewed both that motion in writing and a response submitted by the people. Mr. Harrison, the floor is yours.
Well, Your Honor, in a lot of ways, this is a relatively, I suppose there's no such thing as a formulaic or regular type of motion. This is a motion that was contemplated by the parties and discussed a little bit by the court in our last proceeding in court, to the extent that Mrs. Carey also said, go ahead and file your motion, but I'm going to oppose it. So nothing that's happened so far has come as a surprise in any way. The court intimated to Ms. Plum the last time we were here that you would at least be open to the idea of her receiving residential treatment. And frankly, the court also stated that it wasn't a problem if she wanted to go before her scheduled hearing date. In response to that, Devin has been able to, working with Brian from our office, arrange an intake appointment on February 17th at a residential treatment facility. I don't like to say that it's a form motion, Your Honor, but it contains language that the court has requested we include in such motions, as far as the transportation issue and who's going to monitor what and that sort of thing. I'll be happy to take more questions, but I don't have a whole lot more to argue than what's in front of you, Judge. Thank you.
All right, thank you. Ms. Dahl, on behalf of the people, And again, I reviewed even this morning your response, so.
Thank you, Your Honor. Just to reiterate that Ms. Blum has a drug problem, and that's clear from her record. In the police report, she stated that she just got out of rehab and was clean at the drug house that she was found. There was a search warrant served on the drug house. There was a drug sale at that drug house and lots of drugs found in the house. So
Where was
I
that
find
house? Okay.
in Harrietta.
Uh-huh.
Your Honor, just based on her statement, it's clear that she's not serious about getting treatment and getting sober. I also got some new information that while she's been in custody, she's made phone calls stating that she's ready to resume work with Ms. Keegan. So I believe that her.
Who's Ms. Keegan?
Ms. Keegan, the city.
Hold on. I'm sorry?
To resume work, meaning with Ms. Keegan, the city, Ms. Keegan, I'm assuming drugs.
Oh, I'm sorry. I thought it wasn't Miss Keegan, but you said Muskegon. Okay, now I get it.
I apologize.
That's all right.
So I believe her intentions are not genuine. She's had multiple drug charges in the past where she had opportunities to get the treatment that she needs. I think at this point, she's trying to seek treatment in order to not get further jail time. I don't think she's serious about getting sober, as evidenced by her stating that she just got out of rehab and then immediately placed herself in a drug house. It is the people's objection that this be granted.
When was the alleged phone call or communication where she made that statement? When did that occur? Before or after the plea?
Your Honor, I am not sure. I got this information just this morning from Ms. Perry, so I don't have the details. If the court would like, we can postpone this hearing to another date and I can get more details from the jail.
All right. So part of my reason for asking that question is well, and I'm not challenging, it's not up to the judge. Judges don't get to take a plea and then say, you know, yeah, I don't like that plea. I think it should be higher. I think it should be lower. Courts only get to apply their discretion when it comes to a time of sentencing. And if the people are so heavily concerned, they took what was a life offense down to a 2-year maximum. That would be on the government, not on the court. So I'm taking some of that with a grain of, well, lots of salt, because if she was that big of a drug dealer in Harrietta, then I would anticipate that. And by the way, Ms. Plum, I'm not saying that. I'm just saying if that's what she was and that was the position of the people, you know, they just took a life offense down to a 2-year, which means they know that more than likely it's going to be an intermediate sanction cell. Means it's going to start with the presumption of no jail. But okay, Mr. Harrison.
I'm kind of taken aback by the prosecutor's stance in this matter. Assuming that the prosecutor is not a professional drug and alcohol counselor, someone who has already pre-screened her and said she's eligible and is a good candidate for the program. Not to mention, we also have a social worker who is a trained person as far as evaluating people with drug and alcohol dependency issues. And he's determined that she's an appropriate candidate for this situation. This would not be the first person in the history of mankind that had to go back to rehab. It happens. Unfortunately, it happens. And it happens because for a lot of the same reasons that Ms. Plum was trying to extricate herself from when this occurred. We all know
whose house?
It's Robin and Jeff Plum's house. It's a fairly notorious location.
I'm well aware of that.
She was not living there full time. In fact, she had returned there to retrieve some more of her belongings on that day when TNT paid them a visit. I think the majority of her issue is she gets out of rehab, she gets out of prison, she does have the determination to start a new life, but the only life she knows revolves around the methamphetamine use and trade. that's the cycle we're trying to break, and that's the help we're trying to get for her. As far as her getting less time in jail, I don't think that's even a consideration in this, at this juncture. Devin has told me repeatedly that she wants to go to rehab, whether the court sends her or not. This looked to be a good juncture to get that to happen prior to the return, probably of adjourned or postponed sentencing, in which we could say to you, Judge, she completed another rehab while she was awaiting sentencing.
When was the last time she was in rehab?
It was a couple of years ago. I don't recall the exact date. Ms. Plum would know that.
Ms. Plum, when was the last time you attended any outpatient or inpatient treatment?
2023 through 24, when I was on parole, successfully completed. With Steve Saladay, Your Honor.
Okay.
But if you're asking residential, besides before I came here, I haven't been since 2010, 2012, I believe.
Yeah. Another 23.
All right. Well, when is sentencing scheduled for? Do we have a date, man?
Yeah, we do, Your Honor. Let me
23rd of February?
Yes.
All right. Do we have a PSI already? Sometimes we get them done quickly.
We do not.
Oh, okay, thank you. All right. Well,
Your Honor, with all due respect, I just thought I'd let you know, Brian Potter did say he was trying to find out what happened today before he turned in the PSI. I seen him last week, just so you're aware. Sorry.
thank you. It's okay. It's all right, Ms. Palmer. I appreciate you telling me. I'm not surprised. That would make sense. So. Well, I'm tempted here to make further comments about the whole situation. I will note that in my position, having been on both sides of the courtroom floor out there and having been up here now for over 5 years, that house, that location is well known. I know we had a case last year involving her father, and I don't hold that against her, but it does involve the same location, which even Mr. Harrison acknowledged. And I don't hold that against her. She's not responsible for the sins of the father, but the point here is she's been in this lifestyle, in this world for a long time. And I also want to give credit. I also want to give as much help as I can when people are dealing with controlled substances. Now, I'm also very sensitive as a judge. I know that there was an appeal in that case and there was a court ruling. And what often is disappointing is the appellate courts don't always, or the attorneys for those cases don't always explore the full facts of the case. And by the way, Ms. Plum, do you know what I'm talking about, ma'am?
Yes, I do.
In that case, I stopped the trial, sent the jury out, and we had this conversation. What didn't get found out and put in the appellate record was we had a conversation in chambers where the attorney was warned, don't go down that road. And sure enough, that's what he chose to do. So when I say we all know what's going to happen, it was because we'd all talked about it in chambers. So I don't hold any of that against you either. So that's what I'm trying to be really sensitive to. None of that has any impact on my decision in here. Again, the sins of the mother and the father don't go over to the child. But I'm really concerned about you. I think you're in this world? Yes, obviously you are. Think you have a drug problem? Clearly you do. Do I want to see you stop it? Yes, not only for you, but the community. I think that drugs are the largest criminal problem we have in our county. I can tell you that it's not me being biased. I can tell you that's just statistics. So, but at the same time, I have the chance to send you to rehab and to give you the keys to the prison cell. Which means, because if I send you to this rehab program, which I'm going to do, and you flee, abscond, fail the program, then you'll only have yourself to blame. Does that make sense?
Yes, it does, Your Honor.
The court will grant the motion to modify the defendant's bond. And go back here and take a look at the language again for the court clerk.
Your Honor, may I say one more thing?
Yes, ma'am, of course.
I don't know if you're aware, but my mom did pass away in the beginning of December.
Oh.
So.
I'm sorry, I did not know that.
I assumed the court was
No,
aware
it's
that
okay.
Yeah.
Robin Plum passed away from an accidental intoxication of fentanyl.
Overdose.
See,
Yeah.
see, Devin,
But I'm gonna
that's,
use that, oh, go ahead.
no, I was gonna say, Devin, that's why I say drugs are not victimless crimes. They spill onto other people, they spill onto children. And, I know your mom had struggled. I've seen her here in the courtroom, and when I hear about that, it just makes me feel bad, like somehow we failed, or the system.
No, yeah.
So, I'm very sorry.
I just wanted to, I'm sorry, I don't mean to interrupt, but I just wanted you to know I think she gave her life so I could live mine, and that's how I'm gonna use that.
Well, I'm hoping so, Devin, and I don't mean to use your first name insulting, but I just use it to say, I understand the problem and concerns and how it impacts people, and hear about people not surviving this issue, and especially if they've been in front of me, it really is heartbreaking. All right, the court's going to release the defendant on a PR bond beginning on February 17th at 2026. She will be transferred by, and this will have to be arranged through the public defender's office. She'll be transferred through the West Express, which does do a service for the county, and we need to have that arranged ahead of time. Thankfully, West Express has worked with the county, and we use some of the opioid funding and other funds to help do that transportation. She will be transported to the Sunrise Center. She's ordered to participate in that program. If she leaves that program or she is terminated involuntarily, then her bond will be revoked and she'll have to return to jail. She will also sign a release that will allow community corrections from this court to monitor her attendance. Ms. Plum, what that means is community corrections will only have the ability to check that you're there. That's it. All right, is she there? Is she doing what she's supposed to? I want to highlight that for you so you don't think that anyone else outside of you and your counselors will know what you and your counselors talk about. I just need to know that you're doing what I told you to do. That's all. All right. Now, some of these programs, I can't remember if Sunrise Center does, and they say, well, we don't like to do these because of whatever. You can tell Sunrise Center that if they don't allow just community corrections to check that you're there, I'll have you put back in jail. So you want to make sure that they do as I say. Again, no one is going to know anything about your private communications, okay?
Okay, yes, sir.
I can't monitor you, at least your attendance. And why would I put somebody into a program?
Right.
Your sentencing is scheduled to come up the week after. But I will, if the parties tell me, and Mr. Harrison will be the one in charge of drafting a stipulation to say, hey, Judge, yeah, she's still there, then I'll continue in the program and we'll adjourn your sentencing. Clearly, I understand, and you should understand as well, that I'm using your sentencing to hang over your head. I'm not saying I'm going to punish you. It's not like a stick, but it's your way to convince me that I don't put you in prison. Okay?
Okay, yes, Your Honor, thank you very much.
Yeah, it always sounds awkward, and it's not to be mean, but it's just to say, I'm hoping that you take this opportunity to do all the right stuff. And clearly, I understand that I have this sentence hanging over your head that will hopefully help encourage you to maximize your full benefit. Okay?
Okay, Your Honor, thank you. Thank you very much for this.
Yep. And that means if they give you the opportunity for a sober living facility, I want you to stay in the sober living facility. Now, last thing. Stay away from, I'm not saying you did it. There's no fighting. Stay away from the people in Muskegon.
Yes, Your Honor.
Any further today, Mr. Harrison?
Nothing further, Your Honor.
Ms. Dahl?
No, Your Honor.
Devin? I really sincerely mean this. Good luck, because I'm very bothered. I didn't know about your mom, and I'm very sorry.
I'm sorry about that too, Your Honor. I assumed that was common knowledge.
Everybody thinks I know everything. I don't. So I intentionally get to stay out. And the best thing about being the judge is I don't read police reports unless I'm asked to. And no one ever asks me to do it. So I don't know what goes on out in that world too much. All right, thank you. We're adjourned.
So 2 points of wisdom from Judge Elmore there. Number one, once again, he reiterates that drugs are not a victimless crime. He and I are very much aligned on that view. I've always had that view. And this is yet another example. You had parents that used it, spilled onto the child, that behavior, that lifestyle, and here we go. It becomes generational. Man has a point. I know that a lot of people push back on that, but I don't think he's wrong. You can disagree with me, and that's cool. That's part of what we do here at TCF. We discuss, we debate, we don't always agree. But that's my stance on that one. The other piece of wisdom that he gave was stay away from the people in Muskegon. Having grown up in Muskegon many, many years ago, I don't necessarily disagree with that statement. Anyways, let's head to Texas. Judge Stevens.
Did Darius come?
Yes, sir.
Stand by. Did the room shift or something?
Yes. Yes, it did.
I'm not kidding. I'm not kidding. Things are rolling off this desk. It's never done that before. I just put, and it just rolls right off. That's never happened. I don't know. What else can happen?
Shifted, Judge.
What else can do what?
Maybe the earth shifted.
That's your final answer on Jeopardy here? The Earth's just, well, it probably does all the time. All right. Are you Mr. Comerford?
Yes, sir.
Yeah. And you were here charged with a state jail felony of criminal mischief in 25 CR 769. And does the defendant waive the formal reading of this indictment and the arraignment here? Can we proceed in summary? Yes. Okay. In summary, this indictment, sir, alleges, as you probably intimately know, but we're going to remind you, it states that on or about March 9th, 2025 in Jefferson County, Texas, you committed the state jail felony of criminal mischief. Let's see. Destroying grass and lawn by driving onto the grass and spinning the tires in your vehicle without the effective consent of the Lower Neches Valley Authority. Okay. If convicted of a state jail felony, you face no less than 180 days up to 2 years in a state jail, and a fine up to $10,000 can be assessed. Do you understand?
Sir.
An agreement's been reached where you would be pleading guilty, placed on 5 years deferred or unadjudicated probation. Fine. This fine is odd, $2,320.14. Is that restitution?
Yes, Your Honor.
Okay, all right. What I'm gonna do is I'm gonna put it down here on this little box. These are brand new pads and they don't have a restitution option, so we're gonna fill this in. Is there any fine?
No fine, Your Honor.
And there'll be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Not guilty.
Is that your final answer?
Guilty.
Guilty.
Yes, sir.
Is that your final
Yes,
answer? Okay. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Couple of things we gotta just say here. By the way, have you ever been on probation before? On this? If you do well, I'll shorten it to 1/3, a year and about a year and a half. Then it's dismissed. It's not, you're not found guilty.
On the record.
You can talk about that.
This is going to be deferred when I make the findings, which means there is no finding of guilt. If there's no finding of guilt, you can't be punished in any way. Unless some other authority comes along in another way.
I can talk to you about that.
Which doesn't end. There's some things we have to sign here. On the bottom of that, he's not sign that.
Oh, he needs.
Sign. And I think there's another page before that wasn't signed. And thank you. And so what I'm doing is taking this, I'm also and let me ask you, okay, these are new pads. How do you erase something?
Is there the clicking button on the pen, Judge?
I think that's it. I just click and hold it and then scratch over.
This thing?
And then hold it down.
The button on the pen.
You missed our orientation.
Let me just say I didn't miss it.
That's what happened with you, Judge.
I didn't miss it at all. I don't think I'm missing this at all. Tell you what's marked here, states Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Is everything true and correct?
Yes, sir.
States Exhibit 1, tendered into evidence without objection.
Correct.
Among other things, this states you are mentally competent in your guilty plea. It's freely and voluntarily made. You know what you've been charged with. Indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report waived here.
Yes, sir.
I will follow this agreement. If nothing further, and find you are mentally competent, enter this guilty plea. It is freely and voluntarily made. Even though there's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, I'm not going to find you guilty so long as you follow terms and conditions of probation. The probation officer will go over with you. And you will be deferring any finding of guilt for 5 years. And again, early termination is rewarded for everyone who earns it. Make sure you follow these terms and conditions. If you fail, your probation could be revoked. You could be sentenced. You could then be found guilty of a felony and sentenced up to 2 years in the state jail. So fix this. Okay. Anything else? That is all. See the probation office. Thank you.
So Ashley and Great Granny are both saying that we've seen this one before. No. This is from Judge's feed this morning. It happened about 10 minutes ago. So perhaps if you were flipping through and saw it on somebody else's channel, but it is from today. So we might have seen this defendant before. We might have seen a similar case, but it is, oh, the iPad you mean? Gotcha. Well, yeah, no, the iPad, you see that every day because he's always bitching about the iPads. He hates them. But yeah, the case is new. The iPad saga in Judge Stevens' court, I don't think is ever going to die. That is ongoing and forevermore. Gotcha. All right, we're all clear now. Let's go back to Michigan, though, Judge Simpson.
Everything's in one. Oh. That's true.
Okay.
All right. Back on the record in the Nyquist matter, the record should reflect you had a bench conference in this case. Going to do something a bit unusual. I'm going to adjourn I'm going to adjourn this for a bond violation hearing as well as a potential plea to March 9th, 2026. What time is best for you guys? My docket normally starts at 1, but that date I can do morning or I can do afternoon.
That day, do you have words for counsel?
We have class on that day, so let me just.
Class.
We don't have
Round
nothing.
class. You don't need class. They're here. This is like a big giant class.
Wonderful too. Other.
What?
I said, and they've been wonderful.
They have?
It doesn't matter. Morning. Let's get to the morning, Your Honor, please.
They've been wonderful.
They
You don't
have.
have to say that.
I'm gonna keep
No,
saying.
you don't have to say that. All right. Why don't I set it at 10 a.m.?
That'd be great. Thank you.
Thank you.
Right?
Thank you.
Thank you.
Thank
folks.
you.
Thank you.
Bond will continue with its conditions. Oh, he decided to show. Court calls the case of people versus Adib Shawaka.
Morning, Your Honor. Raymond Cook for the people.
Lawrence Margolis with and on behalf of Mr. Chewaka, who is approaching. Adib, please state your name for the court.
Adib Shawaka. Anytime set for final settlement conference, people are able to proceed.
We've executed a waiver to bench.
Shawaka? You understand that you have an absolute and constitutional right to have the matter tried before a jury?
Yes.
You understand that by signing this form, you're waiving that right to be tried before this court without a jury present?
Yes.
You understand that? People also waive their right?
Yes, Your Honor.
Based upon the statement of counsel, the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter. February 25th, 2026 at 9. That's in person. All right.
Thank you, Judge.
Thank you.
Good weekend.
You do the same. Court calls the case people versus, is it Zeke Church?
Morning, Your Honor. Raymond Cook for the people.
Your Honor, Vincent Hayes on behalf of Mr. Church. Your Honor, can we approach just briefly on this? I don't have Mr. Church present. I can explain why. I'd rather do it at the bench if I could. Thank you.
Whole lot of muting going on in Judge Simpson's court today. Let's stay in Michigan, but we'll go back to Judge Middleton.
That's a legitimate question. When you get a drinking driving charge, they take your license. they cut the corner of it off and they give you a paper license, which is a bitch if you got to fly on an airplane or something shortly thereafter. You don't have a picture ID, you got some funky thing that the police gave you. But that's what the statute says. And at some point, you're gonna have to get another license.
All right.
If I were you, what are you you have a trip planned?
I work for the airlines and travel often.
Oh, boy. I would go to the Secretary of State and get a Michigan ID, if they'll give you one. But yeah, they've cut your license up. So I would go, I'd make an appointment today or early next week to go to SOS in Sturgis or another one. Dowagiac might be closer to you. And see if you can get at least some picture ID. But this problem's been a problem for years. And heaven forbid, you're about to take an airline flight to Jamaica or something and you got this funky paper thing. I don't have a better answer than that, Mr.
Great,
Parsons.
Judge. All right. Do I need to do anything to get a date, or is that just going to give me?
We'll call you and work out a date. All
Nice
right,
to see you. Thank you.
Okay, nice to
All
see
right.
you. I'll
Take
see you
care.
on that date. All right, Mr. Parsons.
Thank you.
All right, so yeah, there's some advice. Don't get a drunk driving arrest before you're about to go on a trip. Let's take Mr. McNally's case. Try to usually do him last, but these are all Jordan Harden. Just 12 or so.
Morning, Your Honor. James McNally on behalf of defendant. Defendant is present. We did have our pretrial this morning, and originally we had worked out an agreement where if defendant paid restitution amount of $140, the case was going to be dismissed. We were going to set it for final pretrial to give the defendant a chance to pay the money, but it looks like he has a $200 bond. So at this point, Your Honor, we would ask the court to take the $140 out of the bond and enter an order of dismissal pursuant to the plea agreement.
All right, the allegation is that you pulled your neighbor's security camera off the house out in Florence Township, and that was worth $140, $139 something. You agree to pay restitution in that amount?
Or anything off the house? No, don't worry about that. The bottom line is you've agreed to pay the $140 to get the case dismissed. Is that correct?
You take your mask off
Yes,
so
yes, Your
so I can see you. The house, I know who you are, but I want to
Did you pull your mask down for the judge? There you go. All the way down.
all the way down. I'll let you put it back. That ain't gonna get it.
All the way down. All the way down.
Hi,
Under your
how you
chin.
doing, Jeff?
All right.
Or Your Honor, excuse me, I didn't mean to say Jeff. I remember you when I was a kid, as
Yes.
a prosecutor.
Yes, that was a long
Tried
time.
not to steal nothing ever since.
Good.
They say, once
Good.
you start stealing, you never quit, right?
Well, this worked
Did
for
I?
40 years. I guess we're doing all right. All right.
Thank you, sir.
Prosecutor
Wrong.
dismiss,
You're very well. I
apply.
had the flu and.
All right, you can put it
I'm
back to
sorry.
140 of bond to restitution to Dawn Taffel. You guys have had neighborhood disputes out there for a while. We've had some of these. How's everything going now?
I'm
the
taking care
complainants
of
are
the
here.
problems that I've started.
Oh. All right,
I'm gonna do the best I can to correct the situation in every manner of way.
all right. Do you ever think about moving?
When we purchased the property, we had no intent, there was nobody living around us. Obviously, they moved in behind us and we were unaware that they owned the property in front of us. And then they buy a property in back of us and they would like to go right on through and own ours too. And, therefore,
like I
everything
said,
I've done in the decade seems to be not good enough.
Well,
And
fence
therefore, we have been
issues
in
and
front of
other
you, yes,
issues.
sir. And I apologize for taking up the court's time.
Well, that's why I'm here. All right, Mr. McWheel will take 140 of his bond. It doesn't appear he has any unpaid fines and costs. He's gonna get $60 back and the case will be dismissed.
Judge, there was an order for fingerprints. Since it's dismissed, does he still need to go through that process or?
I already did, you know.
Okay, I guess they're done.
All right.
All right, Mr. Reingart, how about if you don't come back for a while?
Your Honor,
That would be our.
I apologize for me stealing everything I stole when I was young.
Well, that was a long
I
time
wouldn't-
ago.
I really didn't.
All right, well, you paid your penance.
You're on TV. You don't have to.
30 years ago.
Well, I don't care what I you know, it don't matter to me, I didn't do it.
All right,
All
thank you, sir.
Judge.
Okay, have a good weekend.
All right, Mr. McWheel, thank you.
Thank you, Your Honor.
Rhonda, Tim, Luke, what else do I have for you?
Judge, I'll wait for to show up too, but I do have Mr. Blasius. He's prepared to enter a plea.
All right. Michael Blasius, the other Michael Blasius. All right. This is file 252326 ST. People versus Michael James Blasius. That's you, sir?
Yes, sir.
You got charged with driving suspended, which is probably our most common offense. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You're here with your lawyer, Mr. Luke Knopfinger. The prosecutors agreed to reduce this to a charge of no valid ops. That's 257301. It's a misdemeanor. It doesn't carry a suspension like driving suspended does. It does carry 2 points, carries a fine of $100 maximum and $125 in costs. Do you understand the charge?
Yes, sir.
Are you going to plead to that
Yes,
charge? Anyone threaten you to get you to plead to that?
No, sir.
Or promise you anything?
No, sir.
And you understand you're giving up all the rights on that advice or rights by entering this plea?
Yes, Your Honor.
Where were you going?
R&R trailer to work.
I thought this was your dad, and I thought, oh, not again. But it was you, and you got on the driving suspended merry-go-round. And how are you doing on an effort to get your license back?
It's at least another year before I can even ask for it back.
Yeah, this doesn't help. But it doesn't carry an automatic suspension. Yeah, you were on the way to work, 5:56 in the morning, 131 Lovers Lane. That's clear what you were doing. All right, I'm gonna make the fine 75 instead of 100. Was your license suspended at that time?
Yes, sir.
$75 fine, $50 state minimum fee, $75 crime victims' rights fee, and $150 attorney fee. I don't have any bond. You don't owe any money to the court. Can you pay that within 30 days?
Yes, sir.
I've been giving these envelopes to people for 23 years. And they don't have the court's address on it. They have the court's mailing address on it. So you have to like write the court's address on it if you mail it. That'll be due by March 6th. $350. If you need more time, let us know. This will go on your driving record. You're right, it'll ding you up for another year. But you're not too far from work. Are you still at R&R?
No, sir.
Where are you now?
Nowhere.
All right. Everybody's somewhere. According to Neil Young, everybody says this is nowhere. All right, Mr. Blasius, you're good to go.
Thank you, sir.
Thank you, Mr.
Thank you.
Blasius. Tim, let's take up some of your matters. Jordan stepped out.
I have 4 total, Judge. I have 3 pleas and 1 last pretrial. So
All right, let's do the last pretrials first. Good morning. Are you Ashley Wisdom?
Yes.
Take a look at this. Paul, do you have people back in the lockup?
Yes, there's 3 people back there that are pleas.
All right, why don't you lay those up here? We'll address those. They have to get back in time for lunch.
Put the in custody on top.
Is anybody else? Do you have any in custodies?
No, sir.
Ms. Wisdom, you got charged with illegal entry. It's kind of an odd case, as I recall, from the arraignment. It's alleged to have occurred on October 10th of 2025. Illegal entry is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. He alleges that you went in his house and threw some stinky around and glitter. That's the allegation. Mr. George, we're going to set this for a final pretrial.
That's correct, Your Honor.
Ms. Wisdom, are you still at St. Joseph Street in Coloma?
Yes.
All right. All right. I guess there's not much else to say about this. We'll set a pretrial for a Thursday afternoon. Mr. George has quite a few cases and we try to set them at the same time. You've done a good job. You've been here every time when you were supposed to be. You've been here now for 2 hours waiting for this. And are you missing work right now?
I am. And so Thursday is a concern. I'm not sure if I can get Thursday off.
It'll be in the afternoon. We'll work on that. What do you do?
I'm an insurance agent and I run an agency entirely on my own. Like there is no other person.
I don't have an answer to this.
And once we get a date, Your Honor, if that's going to be an issue, we can always address that with
All right,
the court. And if we
thank
need
you.
to make other arrangements, we can.
But you're free to go now. Yeah, stay in contact with.
Thank you, Your Honor.
I appreciate it.
Okay.
Glitter, huh? Well, who says crime can't be fabulous? I tell you. Texas, Judge Stevens.
Sign here,
What about my name?
right there, that's saying that, he can,
We're good.
he represented you, I think it was.
No, that's not what this is. This is, showing that we've given your attorney discovery.
Oh, that's a discovery, yeah, we got a discovery, remember the video, you didn't look at the video, but I did. So,
Yeah.
and you're also letting him handle the plea, even though you don't even remember it, but he represented you many years ago, I think.
That's been a
Since the 90s, probably, yeah. I don't know.
Yeah,
Yeah.
remember the name. You just
see my name on the top there, this, yeah.
That's a misdemeanor, right?
Yes, sir.
Yeah, but you deserve to, I knew you were putting it on the felony for.
We ready?
Yes, sir.
And we call 25 CR 441, the state of Texas versus Tammy Dunaway Judice. Is that you?
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
We can, Your Honor, yes.
In summary, this indictment alleges that on or about October 19th, 2023, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while you were intoxicated. Do you understand what you were charged with?
Yeah.
Now, if it was only that, that's serious enough. But paragraph 2 goes on to allege that you have not 1, 2, or 3, but 4 prior DWI convictions. 2 of those were felony convictions. We're about to make it the 3rd felony conviction by the improper use of a motor vehicle, which is a 4,000-pound missile, which all too often results in death when it collides with others. My question to you is, when are you going to stop committing these crimes?
Now.
Didn't you make that promise every time that you were pleading guilty?
Yes, sir. I really believed I could. I just didn't.
You in this case?
She's my client.
Okay. Not your mom. She's she's a very wonderful lady.
She's only.
I just, whatever, she has a lot of influence with me in what she believes is right and wrong. And she's always seems to be right.
Good.
Look at something real quickly. Because this is it's high time that this mess gets fixed. Okay, there was a blood draw. And the probable cause affidavit does not report a result. There was a lot of time, though. Almost 4 hours passed from the time she was arrested until the blood was drawn.
I'm looking at something that says, wait for it, 0.012 and 0.009.
Was that the blood or the breathalyzer, those two?
That's the
12.
That's a breathalyzer.
Okay, that's what I thought.
There was a blood test that was positive for codeine, and that's what the basis of the intoxication is, Judge. And the amount of that codeine was 32 nanograms per milliliter.
All right, and again, paragraph 2 alleges that you were convicted of a DWI in May of 2007 out of County Court in Law 3 of Jefferson County, Texas. You were convicted of a DWI on August 27th, 2008 out of County Court in Law number 3 of Jefferson County, Texas. And on December 3rd, 2012 in the 252nd District Court of Jefferson County, Texas. Whose phone's on? Is that yours, Frank?
It was just like it's
No,
not.
okay. You don't need it. That's not an emergency. Is that, let's check it, make sure it's not an emergency.
I'm not.
All right. And on December 3rd, 2012, you were convicted on 2 different cases of DWIs out of the 252nd District Court. And those were felonies. Now, paragraphs 1 and 2 constitute your 3rd felony DWI. We're going to put a stop to all of this. Do you understand? On my watch, I need a pad. Thank you. I can't tell you how important it is for you to stop doing these things. All right. You are facing a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that?
Yes, sir.
An agreement has been reached between the parties that you would be pleading guilty. Whatever sentence shall not exceed a cap of 6 years in prison. So we are looking at no less than 2 nor more than 6 years confinement in prison. You could be sentenced up to 6 years in prison, and then that could be suspended and you could be placed on regular probation. Deferred or unadjudicated probation is not an option in this case. So those, I think, are the 2 alternatives, right, everybody, as far as?
Yes, sir, or possibly even say fee.
I never thought that was a punishment. That's substance abuse felony punishment is I've always considered it kind of a benefit for people who undergo this. But what do you mean say fee? What's your option on that?
He's suggesting it as a condition of probation, Judge.
Okay. Yeah, that would almost certainly be required if that's what happens. Yeah, if she's placed on probation. But we're going to have a pre-sentence report so that we can find out as much about her as possible. If I follow this agreement, you have no right of appeal of your case. Do you understand, ma'am?
Yes, sir.
How do you plead to paragraphs 1 and 2 of this indictment constituting the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated? Is that true, or are you guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? And because that, and because you are guilty?
Yes, sir.
And today to 6.
It is.
7. Paragraph 2, those prior convictions of DWIs, are those allegations true and correct as they are alleged in paragraph 2? That's yes or no.
Yes.
And are you pleading true to those allegations voluntarily and because they are true as they are alleged of
Yes,
those
sir.
prior convictions. I show you what's marked as State's Exhibit 1. Frank, if you'll show her that. But the first thing is you need to sign on the bottom of that. Here's the stylus.
Yeah, that's just.
Is that your signature?
Yes, sir.
Did you understand the contents and discuss all of it with your attorney?
Yes, sir.
Is everything true and correct there?
Yes.
State's Exhibit 1 is tendered into evidence and without objection.
No objection.
It's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. Thank you. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1 is part of the record for all purposes. Now, we're going to order a pre-sentence report, a post entry of plea pre-sentence report, and we're going to reset this until
March 13th.
March 13th. And the probation office will be getting in contact with you and fully cooperate with them so the court can have the most information to make the most educated decision in this case. And we'll return back here in March and we'll complete all of this. Yes, ma'am.
I'm not 100% certain about a phone number. I know that sounds strange.
That's it.
I just changed one recently and.
Well, get it. You're going to get that to Frank, your attorney,
Yeah.
right?
Yeah.
And then he'll get it to us. And then he'll get it to us.
Well, the one on the pleading, she wasn't sure, but I'll give it to you.
But you do have an obligation when you go to the probation office, give them all the information you can accurately. Okay. Okay. Anything else, Frank?
That's.
Okay, please get a resetting. Thank you.
I have some information.
Yep.
Yeah, go still talk to him and I'll get the receipt. Did you just sign it?
You can sign on her behalf.
So 4 prior DUIs, 2 of them were felonies. She's going to get another felony DUI. Didn't we just talk about this the other day? I might have more to say in the 4th hour. We'll see. Let's head back to Michigan, see again what's going on with Judge Simpson.
Court Judge Torshell Feaster, First Assistant Public Defender, on behalf of Mr. Bond Sanders, who's approaching the podium. Please state your name, sir.
Deja Bond Sanders. Thank you.
Thank
You need your half of the waiver.
Oh,
I already had the people's half.
apologies, Judge. We likewise do not believe that a conflict exists in any of these cases before the Honorable Court this morning. But should a conflict arise, we would waive said conflict and allow the Honorable Court to please hear these matters.
And the court also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. All right.
Thank you, Judge. I have spoken to Ms. Zenda on this file. I believe they are not able to proceed.
And that's correct, Your Honor. So it is taken as a final settlement conference at this time.
So I'm going to hit the pause button on Judge Simpson because his feed just reset on me. That is old footage. So let me see what's going on there. But in the meantime, let's go back to Stevens because he's got a new contestant approaching, I believe.
Bye-bye. Thank you. Does he need to go in front of you? In any, it's a plea, it's going to be entering. You were,
TRP.
you were, but you're going to be pleading on this motion to revoke probation? You're going to enter a plea of true? Okay. Are you in 19-32947, are you Gregorio Lakeith Renfro?
Yes, sir.
You are here with Ryan Kimber, your attorney. The state's attorney is here. And looks like you're probation officer, right? You have been on probation, it looks like, for about 6 years. in this court. And there is a motion to revoke probation that has been filed as of October 2nd, 2023. I don't know why that has been pending for over 2 years. Have you, was he an absconder?
Yes, sir.
Yep. All right. Have you had a chance to discuss all of this with your attorney?
Yes, sir.
All right. Are we ready to proceed today? You're going to be entering pleas of true?
Yes, sir.
All right. And again, does the defendant waive a formal reading of this motion? We can go in summary.
So waived.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion to revoke probation alleges that on January 27th, 2020, in this criminal district court of Jefferson County, Texas, you were sentenced to 5 years in prison, and that was suspended for 10 years probation for the third-degree felony of evading detention with a motor vehicle. Is all of that true and correct?
Yes.
Allegation 1 states you failed to report to the Jefferson County Probation Office on or about September 14th, 2023 in violation of your probation order, which condition 4 states that you will report regularly as required of you and directed. Did you fail to do that?
Yes, sir.
Are you pleading true to this voluntarily and because it is true as it is alleged?
Yes.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke a probation. Your probation can be revoked, and you can be sentenced to the full range of punishment. This is a third-degree felony, so you were looking at no less than 2 nor more than 5 years confinement in prison. Do you understand? Knowing all of that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. How long was he out?
He absconded for a period of 2 years, 2.5 years.
Okay.
To be exact.
Do we need an updated probation report if he's been gone for 2 years?
I'll defer. He could explain, I suppose.
What do you want to do, Ron? Did you want to
I would
do anything today or recess it?
What do you feel? Do you want to proceed today, or you have a chance to do an updated report, or can you explain to the judge why you were MIA for 2.5 years? What's the updated report? Well, to explain what your situation was and why you may not have reported. Yeah, you want to do that? Okay, let's get it updated.
Okay, that's what we'll do. We'll return back in how much time do we need? 3 weeks? 3 weeks. Let's reset and we will come back for a disposition hearing at that time. We'll see what happens, okay? All right, thank you. That is all. Anything else? We're in recess.
All right, let's go back to Judge Elmore, see what's going on there.
Violation. Back on February 4th of this year, which is only a couple of days ago, there was a request and summons for a probation violation, and an amended one was filed. Initially, the request and summons for a probation violation that was initially filed on January 21st of 2026 included 2 counts. Each count alleged a violation of probation for possession and use of alcohol. The added count included added count 3 and added count 4. Mr. Swiderski, I need to tell you that added count 3 alleges another violation of condition 2.0 and alleges that which of course requires that you are not to use or possess alcoholic beverages or other intoxicants. It alleges that you used alcohol, on a different date. That was on December 5th. Added count 4 is that you possessed alcohol also on December 5th. So you've got two allegations. Counts 1 and 2 deal with December 15th, and add counts 3 and 4 also deal with December, but deal with the date of December 5th. So about 10 days apart. As to all 4 counts, again, you have the same rights, the right to challenge these at a contested hearing, have the prosecutor prove the allegations by a preponderance of the evidence, question or cross-examine any witnesses against you, that have the right to present witnesses, evidence, or testimony if you chose to do so, as well as the right to remain silent and not have that silence used against you. All right, and you have the right to testify. And again, I will note that it looks like our original arraignment or show cause on the first summons was earlier this week on February 2nd. All right, Mr. Hartel, were you aware of the amended request and summons?
Yes, Your Honor, and I did discuss that with my client as well.
All right, thank you. Oh, and as a reminder, Mr. Swiderski, if you're found to be in violation of your probation, be resentenced on your original charge. That was possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Ms. Odell, it seems like have there been any other prior probation violations?
There have not, Your Honor.
Okay, all right, thank you. I'm sorry. For some reason, I thought there had been a written acknowledgement on one. Mr. Swiderski, then I need to tell you that of the 4 counts, they are all 4 technical accounts. However, even though they are 4, the law requires me to treat them underneath the same series of transactional events concept. So while there are 4, 2 deal with the same day of December 5th, and the other 2 deal with the same day of December 15th, which means as far as punishment goes or sentence goes, it's my understanding the most I could give the defendant would be up to 30 days. Does that make sense, Mr. Hartel?
It does, Your Honor.
Thank you. All right. What does your client wish to do, Mr. Hartel?
Your Honor, he's advised me that he would wish me to ask the court for a contested hearing.
All right. Thank you very much. Mr. Swiderski, this will now be set for a contested hearing. Mr. Hartel, I'm not aware of any. Are there any new charges coming out of these anywhere? I don't know what the background is.
Not to my knowledge, no.
All right. Any issue then within the 14 days, which the 14 days would have began on Monday, this past Monday, so it will be next week. I've got at least a 3, if not a 4-day long trial. So it'll be in the following week. Or it might. Am I in Misaki next week, Miss Odell? Next Friday? Or Miss
I don't believe so, Your Honor. The clerk is checking.
I'm checking.
All right, hold on. Thank you.
You are not here. You're gone next Friday. You're gone next Friday, Judge.
Yeah, I heard you. Am I going someplace fun?
I'm not sure.
It's okay, neither am I. So, all right. Well, anyways, maybe my wife had the staff put it on the calendar. All right. So, anyways, Mr. Hartel, I don't want to kick it out a long time. What when the party has waived their 14-day, I'd only kick it out maybe to the next week.
After conferring with my client, we would be fine with the court sitting it out as far as the court felt comfortable. He is amply employed, and just to err on the side of caution, in case he does have a finding and in case there is jail, he would like to be able to get his affairs in order. So more time would be preferred versus less time. Thank you.
Mr. Denham, that's up to you now.
Yeah, no, the people would also waive any time requirements. Next week I have a conference as well, so it would work out better for people as well.
Likely it's a Friday for me. I'm probably in Lansing. So, all right. Mr. Swiderski, what we're talking about now is setting this for a contested hearing. I want you to know that at a contested hearing, you can't appear via Zoom. I need to have you present, okay?
Yes, sir.
All right, thank you. The reason for that, so you understand it, is theoretically there could be a sentence if there's a finding of guilt, but also it becomes really difficult for you to sit there and converse with your attorney if you're not present. Hopefully that makes sense to you.
Yes, sir, it does.
All right, good enough. Thank you very much. Anything else, Mr. Hertel?
No, thank you.
Anything else, Mr. Denon?
No, you're right.
Bond hereby continues as previously set by this court. Again, these are requests and summons for probations, and we're dealing with offenses, and really there's only 2. So, all right, we will see you here once the court sets it. Thank you very much. We are adjourned.
Okie dokie, let's stay in Michigan, but we'll check back in with Judge Middleton.
Complainant, we got victims here on that case. Let's make a brief record.
I'm gonna grab.
I don't have the paperwork on that.
Is this communicated with me around?
What?
Is this gonna be something that I need to address?
No, you can stay. This will take just a minute. It'll be kind of delicate. We're on the live feed. Have you got the paperwork on that?
I don't. We're not going to jury room right now.
Oh, I see. All right. There is, what's the defendant's name?
John Beachy.
John Beachy. The defendant is here and the complainants are here. And we are having some medical difficulty in the jury room. And so Mr. Beachy's attorney is going to be unable to appear. So for those of you that hear on the Beachy case, check in with the prosecutor's victim advocate, but we're going to have to reset this. We don't have any, we're just going to have to reset it. So I don't want to make you sit here for another 2 hours. Kendra is there. She'll tell you what we know, and we will keep you posted, but you're good to go.
Thank you, Your Honor.
Thank you, Ms.
Thanks,
Davis.
Judge.
Yes. All right. We'll go back to Tim. We'll try to get him out. Ruth Minkel. I haven't seen Mr. Cyber in a long time. Sorry to hear it. Are you Ruth Minkel? File number here is 252290. You're here with your lawyer, Mr. Timothy George. You're charged with operating with a high blood alcohol level. That's a misdemeanor. It's punishable by up to 180 days in jail, fine of up to $750, requires that your license be suspended, and it carries 6 points. Prosecutors agreed to reduce that to a lesser charge of operating while intoxicated. That is a misdemeanor. It's punishable by up to 93 days in jail, fine of up to $500. It carries 6 points and requires your license be suspended. You got arrested on November 9th on the Big Hill at 131 and Drummond Road. They arrested you and they sent your blood to the crime lab and it came back at .247. Is that correct, Mr. George?
Your Honor, it came back at a .285.
285, okay.
Yes, the 247 was the preliminary test.
Ms. Minkel, are you going to plead to that charge of operating while intoxicated?
Yes.
Yes, sir.
Anybody threaten you to get you to do this?
No.
Or promise you anything? You understand that by entering this plea, you're gonna give up all those rights that were on the advice or right sheet that was, had you go ahead and sign it? Where were you going?
I was, I was on my way back from Myers. I'd been to the store to get some cat food and some cat litter before it started snowing. And, I was in the process of, trying to stop drinking. I go to AA and I've been to rehab. And the doctor had given me Ativan for withdrawal symptoms. I took it at 4 o'clock in the morning because I woke up all shaky. And then I went back to bed. And then I noticed that there was no cat food. And so I thought, well, I'll go in before it starts snowing. So I went into Myers and I was in Myers walking around about 1 o'clock and I started shaking again. And I didn't have any Ativan or anything. And so I made the stupid decision of knowing that if I had a drink, it would take the shakes away. And I thought about it. There was nobody available to come and get me. And I live alone. I have no family around. I just have some neighbors which would have come and got me if they hadn't been working. And so I made the stupidest mistake I've ever made in my life.
What did you drink?
So ashamed.
What did you drink?
Gin. I think it was a little bottle of gin. I didn't drink the whole bottle.
Well, you did. 0.247 is near the point where they have to take you to the hospital.
No, the officer poured it out on the floor.
Okay, did you have some alcohol in your system from before?
Because I was taking the Ativan to stop.
You're lucky you didn't kill yourself. I'm glad you didn't. Do you still live in Constantine?
Yes.
You really? You know how many points you have on your driver's license? 0.
I know.
You got a completely clean.
I have never drank, I swear to God, and got in my car before. So
Well, you almost croaked yourself and everybody else that was driving down 131. That's a very dangerous spot.
Yeah.
I can probably, within 30 seconds, name off 10 fatal traffic accidents right there at that spot.
You see, I feel that the Ativan that I had in my blood.
This wasn't the Ativan. This is
No,
alcohol.
I mean the mixture.
Well, it certainly made you more dangerous to drive on the road. People called 911 and said, hey, there's somebody in a red Equinox all over the road. And they stopped you. You told the officers you drank wine. But anyway, we'll try to get a handle on all this. This will be something we'll have to figure this out. So we're going to set it for screening and sentencing on a date that works for Mr. George. Tim, have I already got you set for some of those days?
I have March 2nd. I don't know if that's too full.
I think, let's see what we got. It was pretty full. No, that will work fine.
Okay.
You got Mr. Kindig that morning. Let's set it for March 2nd. I've got some Jordan days that are quite full. When you say you've been to rehab, how recently was that?
In 24, and I was sober for a year. I got my coin. In fact, I have all my coins with me.
People have given me some coins over the years. I'm honored when they do, but I've got several. I've got a year coin.
And I've been seeing a therapist for two years, addiction therapist for 2 years.
All right, well, that's a good start. What kind of work did you do?
I was in nursing.
All right, I think I knew that. You had a different name. Horvath? What was your previous name? Hackworth?
I'm sorry?
What was your name before it was Minkle?
Oh, before?
Yeah.
Creighton.
Oh, all right.
I've been married twice and both my husbands were Vietnam vets and they both passed away.
Where are you from originally?
England originally. I'm quarter Irish.
All right, we'll set this for March 2nd. At 11 o'clock. I want to know about your treatment, your AA attendance, all that stuff. We'll get more information about this.
She did provide that, she has that documentation with her today, but we'll make sure that the probation
Very
department
good.
has
We'll
it.
get a head start.
Yes, sir.
All right, I'll see you on March 2nd at 11 o'clock.
Thank you, Your
Go
Honor.
with Mr. George. Paul will finish Tim's. I'm sorry, Jordan, and then we're gonna do Paul's in custody people. Because we need to get them out of here. I don't know why I thought her name was.
So while he racks up the next contestant, just some thoughts on the fourth hour today. I told you when we launched the fourth hour a few weeks ago that it would be a work in progress, and we'll evolve it and just kind of see. But I think it makes sense, and you tell me if you feel differently in the chat. I think it makes sense for Friday, for the fourth hour, to split it up. Do the first half hour of dungeon court, and then the second half hour of discussion, commentary, that sort of thing. Because we try to have a little bit more fun on Fridays here. So I'm thinking taking a half an hour of it for dungeon court. Let me know what you think of that in the chat. I think it makes sense, though.
Good morning, sir. Are you Dana Horvath?
Yes, Your Honor.
You're charged with malicious destruction of a building less than $200. They don't know how much the restitution is. Let's take a look at your ticket. Find your case. All right, Mr. Horvath, it's alleged that on or about April 7th of last year, you destroy a building on US 12 in Montville Township that belonged to Larry Pennell, less than $200. According to the affidavit, you got in an argument with your neighbor and kicked in his front door and broke the door frame. He admitted to kicking Larry's door, but you were mad about some comments he had made about one of your relatives. And then you were charged with this. All right, malicious destruction of property, the way this is charged, is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Doesn't affect your driving record at all. They allege this was worth less than $200. Do you understand the charge?
Yes, Your Honor.
Did anybody promise you anything to get you to plead to that charge? No. You don't appear to owe us anything. Tell me what happened.
Well, he's been a good friend of mine, and I gave him a washing machine. It was his broke for his laundry. And that same night, he somehow got a hold of my cousin's wife and was trying to solicit her on the phone. So I went over there to tell him it was unacceptable behavior, and he did. And he slammed the door in my face, and I kicked the door in. but then I left. And I left him the washing machine. I told him he could keep it for the damages on the door.
Well, they've had from April till now to figure out how much this was. You posted $100 a bond. You spent one night in jail. I'm gonna order 1 day in jail credit, 1 day. I'm gonna order $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee, $150 attorney fee, which makes this pretty expensive. That's $350. I'm gonna order $100 restitution to Larry Pennell. You have $100 of bond, so we'll pay him with your bond. The rest of it, if it's more than that, he can take it out of the washing machine, I guess. You know, $350. Can you pay that today or need time to pay it?
I can pay it today, right?
Very good. All right, this matter's done. Your bond's gonna be applied to the restitution. They can use that to pay him. This happened in April, it's now February. It took 10 months to get this resolved, but it's over with. You don't seem to owe us anything else. Spent a night in jail, which is probably no fun. For at least some time in jail. Mr. Horvath, you go out to the counter and pay that fine, and then you're good to go.
Thank you, Your Honor.
Thank you, Your Honor.
That's what I have, Your Honor, is Mr. Decker.
Gregory Decker. Good morning, sir. You Gregory Decker? File number is 252387. I don't know that I've met you much. Are you Greg Decker's son?
Yes.
Okay, that's what I thought I'd seen, but you're his son. We had a case like this earlier. You got charged with leaving the scene of a property damage accident. That carries 2 points. They're gonna allow this to be failed to report an accident to fixtures. 257621, that carries no points. Do you understand?
Yes.
Anybody promise you anything to get you to plead to that?
No.
Or threaten you?
No.
And do you understand by entering this plea, you're giving up all the rights on the advice of rights?
Yes.
All right, just like the last guy, tell me what happened.
I was on my way home and the rear end of my car started like shimmering. I tried to save it, but I couldn't. Lost control.
Where were you coming from?
My grandpa's.
Which is where?
In the Grove in Mendon.
All right, M60 near Parkville. It was November 12th, 11:15 at night. What'd you hit?
I didn't hit anything.
Did you hit another car?
No,
Failed to stop an ID hit and run. So did your car, what happened to your car?
brokers told it.
All right, so you left it there on the side of the road
Yes,
and then you walked to your grandpa's?
yes.
All right, as I said, we often think these are drunk drivers that got away, which might be what this was. But it's gonna show as a no. Darn it. Laura, I'm out of generic judgments. I got a bunch of assault and battery judgments, which I don't need. So I need some general ones. Well, doctor went up. I need some judgments, blank ones,
Just
the generic
general.
ones. What do you do, Mr. Decker? Do you work someplace?
Yes.
What kind of car? This was a 2009 Mercury. What did it do to the car?
Nothing really.
So what, the last guy, his car was totaled. They just towed it and then you had to go get it.
Yep.
How much did it cost you to get out of impound?
600.
Oh boy. It was an expensive night. You live on Fifth Ave?
Yes.
All right. Your dad used to live at Parkville, but he wasn't living at Parkville at that time?
No.
I didn't think this would be that hard, but all right, the fine is $75. Rest of these are costs. There's a $50 state minimum, $75 crime victims' rights fee, and $150 attorney fee, which makes $350. That's a lot. You owe $1,734, but I'm not sure they haven't confabulated your case with your father. Do you have that many unpaid tickets?
I don't believe so.
All right, we'll find out. Let's take a look at that. You're Gregory Dean Decker Jr.
Yes.
No, that's you, 20. I'm not sure everything is you, but some of them are. You got unpaid fines that you're gonna need to deal with. So I'm gonna put you on a payment plan. If you want, I put you in jail and wipe all these out. Would you rather do that? Or do a payment plan to pay your fines and costs?
Payment plan.
Yeah, I want you to do that. You've got multiple unpaid tickets back from last several years. and I want you to pay it. When did you last work?
Yesterday,
All right, where was that?
Vicksburg,
Where do you work?
GRBS.
Okay, good. Well, then you should be able to set up a payment plan to pay on all these fines. All right, Mr. Decker, would you take them out to the counter? We're gonna try to address some of Mr. Gibson's in custody defendants. Let's start with Mandy Allen.
Thank you, Ron.
Thank you, Mr. George. We'll bring in Mandy Allen.
I think for a couple of them,
No, we'll start with her.
I have a plea sheet. Let's see.
I think this one mine now anyways.
All right, well, Judge stepped away. Let's do this. Let's go to El Paso and their jail magistrate. He's always fun.
2015 possession of marijuana, criminal trespass out of California, DUI history. He's being accused of a number of possessions with intent to distribute a controlled substance, one simple possession of a vape pen. Ms. Quevedo?
Thank you, Judge. Your Honor, Mr. Armendariz lives at 136 Red Robin. He indicated that he is a provider for the gentleman that lives at that house. He's lived his entire life here in El Paso. He is a U.S. citizen. He completed up to the 9th grade at Burgess High School. He has one minor child that lives here in El Paso. He has his entire family here. He indicated that he has no money to post, but can be reached at 915-80 asking for PR bonds or any relief the court might find fitting. Thank you, Judge.
Ms. Carmona?
Yes, Judge. So this occurred on 2/3 of 2026. Basically, the Narcotics Division were conducting an ongoing investigation at an alleged address that was known to be trafficking narcotics. There are a couple co-defendants in this case. So basically, one of the co-defendants leaves the apartment. They traffic stop based on a violation. And when they do that, they find narcotics on his person. He had a child in the car, so they call out the co-defendant, female, Bernal. She picks the child up. She goes back to the residence. They continue surveillance on the residence. It's an apartment. While they're doing surveillance, they observe the defendant to arrive. He enters the apartment empty-handed, stays for a short period of time, and then he exits the apartment with a blue reusable Walmart tote, a yellow duffel, a black backpack, and a smaller blue backpack, and places them in his vehicle. They initiate mobile surveillance. He fails to signal a couple times, conducts an unsafe lane change, cuts off several other vehicles, causing them to brake in order to avoid colliding with the defendant. So based on that, they do a traffic stop. They have him step out because he doesn't have his driver's license or vehicle information. They see several glass pipes in his front left jacket pocket. They call out a canine alerts. Search of the vehicle, they find the following narcotics, as you mentioned, 1 vape pen, 298.97 grams of fentanyl, 7.97 grams of MDMA, 11.06 grams of cocaine, 2,024.76 grams of methamphetamine. He did state that he was called to the apartment by co-defendant Bernal, who asked him to remove the narcotics from the apartment after co-defendant Herrera had been arrested. So Judge, based on the amount of narcotics that are involved, the state would be opposed to any reduction in bond and his criminal history involving drugs.
All right. Mr. Armendariz, I'm denying any bond reduction based on the nature and circumstances of the alleged offense and for the future safety of this community. Do you understand that?
Your Honor, I've been very cooperative. I mean,
Mr. Armendariz, thank you very much. It's probably in your best interest not to say anything else. Right now, you're on Zoom. We're live. Okay. Speak to your lawyer in private, and your lawyer will know what to do. He can always request another bond hearing in the future. All right, sir? Thank you. Next. Officer, do you have Oscar Armendariz on that floor?
Oscar Armendariz?
Yes.
I don't have him on my list.
You don't have him on your list?
No, sir.
Okay. Give me a second. Oscar Cheyenne Armendariz?
No, sir.
He is in 650.
650. Okay, no, I'm not on that floor, sir.
Okay, ándale pues. Sir, what is your name?
Garcia Marco, sir.
Garcia. Okay, Mr. Garcia is here on a criminal mischief. $500 bond. Risk assessment level 4. Multiple felony convictions and I'd say about 15 misdemeanor convictions for various offenses. And he's got a this pending criminal mischief. Failed to appear in 2018 on several cases, 2019 on several cases. Ms. Quevedo?
Thank you, Judge. Let's see. Mr. Garcia indicated that he lives with a friend at 7333 Wisteria. He's lived about 15 years here in El Paso. He attended school in Brownsville, where he completed up to the 9th grade. He has work here in El Paso. He indicated that he does side jobs. In terms of the failure to appear, Judge, he didn't know about the hearing. Mr. Garcia, why was it that you never reported?
The reason why I never reported was because I did report it. I did report it a couple of times, but the last time that the court the days before that I had the court, I didn't know that I had the court, so I didn't really report it that time because because I was supposed to call them like a week later, and I didn't know that I had court, so I just didn't call, and I didn't know that I had the court date.
Okay, Mr. Garcia, just understand that it's your responsibility to report and to attend your court hearings, okay? If the judge were to let you back out again.
Okay.
He indicated that he can be reached at 915-239 PR bond or any relief the court might find fitting. Thank you, Judge.
Ms. Carmona?
Yes, Judge. So this is a PR revocation. As Ms. Quevedo indicated, it was a fail to appear to a pretrial on 1/26/26 and failed to provide and maintain current info with the CJC office. They made attempts, I guess, to contact him, and that was not successful. He just has extensive criminal history, Judge. Cameron County, Harris County, here in El Paso. I just wrote down the convictions, and there was just many. He recently pled in 2025 to 1, 2, 3, 4, 5, 6 cases. And so just based on the fact that he can't comply with the PR responsibilities and his extensive criminal history, the state would be opposed to him being placed back on a PR bond.
So
Mr. Garcia, I'm going to deny any bond reduction based on prior non-compliance with the conditions of your PR bond.
So I'm gonna get time served for a criminal mischief. That's only like 2 days.
Okay. We'll talk to your lawyer. All right? He or she is probably going to go see you sometime next week.
Okay,
Thank you, sir.
God bless you all.
Thank you very much. Have a good day. Next. Good morning, sir. What is your name?
Carlos Rodriguez.
Mr. Rodriguez. All right, Mr. Rodriguez is here on a driving while intoxicated charge. Risk assessment level 4. Multiple felony convictions, which are kind of old. The last one is in 2013. Misdemeanor convictions as well, including 1, 2, 3 DUIs, one of which is pending. He also has a pending possession charge. Ms. Quevedo?
Judge, I believe that this is a DAR from 2024, and let me see. I don't know if this is correct, but the the summary says that it's a 0.02, or the summary that Adam provided. Anyway, Mr. Rodriguez lives with his children. He's lived his entire life here in El Paso. He lives at 760 Pablo Silvas. He is currently not working and therefore doesn't have a source of income. He can be reached at 915-296-0414. He is asking for a PR bond.
Okay, Ms. Carmona, what was the BAC on this case?
0.199.
0.199.
No, 0.199.
0.0199? At least that's what Adam put, 0.0199.
No.
0.199.
So basically a 0.2.
Yes.
Okay, sorry, there was, the summary had 0.0199. That's why I got confused. Okay.
Yeah, yes, and it was a collision, Judge. It is a DAR, but the date of the offense was 7/23/24. It was a collision. He fled the scene of the accident. He obviously signs of intoxication, all the DWI components. He refused, because he was in an accident, he had injuries and needed to be transported to the hospital. So they were not able to perform the field sobriety test. They did do a blood draw though, and as stated, the results were 0.199.
Ms. Rivera, is he out on pure bond?
No,
on the felony case?
He is pending a drug case in the 34th, but I didn't look at the bond on that one.
Okay, there is a certificate of of bailiff. Apparently, he missed court on the 27th of June of last year, but I don't see a warrant being issued as of yet. Jackie,
Yes, Judge.
is there a warrant issued on the felony or pending to be issued? I don't see a judge inside.
Let me double check, Judge, because this is an OCO. So
I'm sorry? No, I'm talking about the felony case. He was set for a plea hearing on June 6, 2025 on the felony, and then apparently he failed to appear for that plea. There is a court setting for a status hearing on February the 12th. Okay. All right, sir. On this case, I'm going to release you on a personal recognizance bond under DUI conditions. Don't use drugs or alcohol. Stay in contact with the PR bond office. Do not commit any further crimes. You're going to install an interlock device on your vehicle. You cannot use any other vehicle unless it has a similar device installed.
I don't drive, Your Honor.
I'm sorry?
I don't drive.
You don't drive?
No, sir.
You don't have a car?
No, sir. I do public transportation.
Then you're going to have a portable alcohol monitoring device. You understand that?
Understood.
All right. Thank you very much, sir. Have a good day.
We're going to jump floors, Your Honor.
All right, friends. As I promised at the top of the 4th hour, we would go to Dungeon Court. For those of you who might be new to the channel who haven't experienced Dungeon Court before, simply put, it is our guilty pleasure here at TCF, and we try to do a little bit of it every Friday. And I think we'll make that the first half hour of our final hour every Friday now, when we can, unless it's not running or something. But here's the shtick. It's bad, and that's the whole point. Just lean into it. The audio sucks. It looks like it's in a dank, dark basement. The lighting is from the Soviet era. It's very Cold War. You can hear the screams of the dead souls in the background and a printer that never stops printing. It's all part of the fun. Ladies and gentlemen, enjoy Dungeon Court.
Is Ramona Coleman here? Can you come up here?
To get a report. Yes, it is.
Real quick, while he's between contestants, I realized that there's newer members here who aren't as familiar with Dungeon Court. We've actually made a Dungeon Court brochure that I am happy to email to you if you're a channel member. Simply reach out to me via email so I know where to send it, and I will send you an electronic copy of the official Dungeon Court brochure. It's a must-have.
May we approach, Your Honor?
Yes.
So she's been it's a mess. Her son also got charged with EMS, aggravated mess. Now, we're glad he's here. We want that to continue, but we're going to pursue those charges. So, I think that if he doesn't plead guilty to that, we set up a trial. Well, I was not yet about that. I mean, what I would do want to do at this point is to see how it does in treatment, make sure it doesn't cause any problems. I think we have to do that in the places. But all we can do is treatment, doing all of the treatment. This is kind of the same thing that happens. You know, what is the treatment before? Yeah. And it didn't work. And they came up with a different situation. I mean, that was situation. I'm just anticipating to complete to be fine. Yeah. Okay. I think we need to see whether it's trial or trial. We need to. Yeah, that's to kick it around. Yeah.
I meant to ask if his ankle monitor can be removed. It's unnecessary.
Okay, so I'm going to need William Spalding.
This really is just alcohol.
Roger, you represent William Spalding, right?
No, I think it's Butch's case.
Oh,
He's here.
He does not, Mr. Morphy.
Butch.
Just got a text. Mr. Spalding does not have Medicaid, he has Medicare, so that's a different animal. We're going to have to talk about that for treatment.
So we're going to have either a final pretrial or a trial judge. I just don't feel comfortable advising my client kind of off the cuff, just enter a guilty plea and hope sentencing goes well. I need to discuss that in a little more depth with him, so however the court wants to handle it, set a bench trial or a final pretrial, then set a trial. I'm Philip.
Well, I'm okay with another pretrial, but we should be pretty quick.
We absolutely, yeah. It's my March availability.
Well, I'm thinking February.
Or I'm sorry, I said March. February availability is any Friday and also, any Friday, the 23rd also.
Let's do the 27th.
Okay, I can do that.
The 20th is already pretty booked.
Yeah, I've got several. That 27th is better for me, Judge.
Okay, one more. Well, there's a felony in here too.
There is a felony, and I just discussed that with Ms. Coleman, and she says it was an old prescription from 2022. She didn't even know it was missing until he got arrested, and apparently he had it in his possession. And it is serious. It's not necessarily to her because she didn't even remember that she had the prescription in the house, but we certainly, we could take it to the grand jury if things go in a way that, especially when we're going to agree to try the misdemeanor cases here and then just disregard the felony case. I mean, it seems like maybe we should reconsider that. But we're okay with one more pretrial and one more preliminary hearing.
We'll talk about all that. And Judge, I would ask if the court would consider
So that's not off the table, taking the whole case to the grand jury, and you could take the felony and the misdemeanor.
Yes,
that's my understanding.
But we'd rather resolve it here.
So we're going to know that whether it's going to be resolved here or not on the 27th.
Yes, we're going to talk, and I just feel better bouncing everything off my client, what's good, what's bad. I would ask the court consider taking off the ankle monitor. I don't think the treatment facility is concerned at this point. It's an alcohol kind of only that you could do.
You're agreeable?
Yes, it's like a Dr. Jekyll, Mr. Hyde. I have absolutely no concerns of him leaving or not doing exactly what's required of him.
Okay, I'll order ankle monitor removed. You'll need to check in with Mr. Major in probation to get that done. Well, it should have been on CRA 2600. Okay, next hearing, February 27th.
Thank you, Your Honor. See you, Chair. State of Ohio recall William Spalding.
under CRB 25601, UCDG.
Okay, so this did not work out with RRS because Mr. Swami has Medicare. He does not have Medicaid. So we're going to have to get a provider that can accept Medicare. Can counseling center take Medicare? No. OVP can.
Cardinal can come out.
And Cardinal.
In this case, speak with all, Your Honor.
Yeah. Okay, we're going to work on trying, it's going to be probably Cardinal or OVP, so let's, there's phone calls being made, so let's see what we can work out. So let's have a seat.
Your Honor, we're ready to call some of the inmates that are acting home.
Okay, we've got inmates in person, we're going to do their cases now.
State of Ohio versus Andrew J. Farley, case number CRA 2678, A and B, CR.
Sir, you're Andrew Farley? Yeah. Farley, Judge Capper, you have the right to remain silent, you don't have to say anything. If you do make statements that are on the record, they can be used against you. You have the right to an attorney, to have one appointed if you can't afford one, to have bond, and to make the state prove the charges against you beyond a reasonable doubt. Do you understand those things? Yeah. You got charged with intimidation and vandalism. And domestic violence and unlawful restraint. So you have 4 charges. We'll start with intimidation. 78A is the case number. It alleges February 2nd, Union Township, knowingly by force or unlawful threat of harm to another person, that person being Cheryl Simmons, you attempted to intimidate Cheryl Simmons in the following criminal charges. So that's a felony of the 3rd degree. The maximum penalty is 5 years in jail and an $8,000 fine. 78B alleges vandalism. That February 2nd, Union Township, you knowingly caused physical harm to property that is owned by Lawrence County Community Corrections. And that's used in their profession. Looks like it was something in the patrol car that was damaged. That's a felony 5 damaging, vandalism, maximum penalty is a year in jail, $2,500 fine. 79A alleges February 2nd, Union Township, you knowingly caused or tried to cause physical harm to Cheryl Simmons. That Cheryl either lives in your household or is part of your family. So that makes it domestic violence. Maximum penalty, 6 months in jail, $1,000 fine. And the last charge is unlawful restraint. It alleges that you, on February 2nd, without the right to do so, restrained Cheryl Simmons in her liberty. That's a 3rd degree misdemeanor, maximum penalty, 60 days, $500 fine. Do you understand these charges? You had money to hire a lawyer.
No,
You have a job.
I did until I got locked up.
Where was that?
On Big Branch Road, I work for a man, making $15 an hour until I got locked up.
Okay, but do you think that job's gone now?
I can get it back if I got out.
Well, do you have any money to hire a lawyer with?
No.
Okay. Mr. Smith, I'll appoint you.
Yes, sir.
State's position on bond, Mr. Farley.
State would request a $50,000 cash surety bond.
Okay, I'll set it on at this point at 50,000 cash surety.
We're also asking for a protection order, Your Honor.
And order him to stay away from Cheryl Simmons. Mr. Smith, do you want to file?
Judge, I spoke, he says he can't make a $5 bond, so we can set it. And we hear around here. I don't think, you
You can't plead guilty. He's been in custody since the second. We either need to set a Monday or a waiver until next Friday. Because the 10 days will run on Thursday. Did you go, that would have been Monday. That's why I didn't ask you to bring it before. Anyway. Did he go in custody on the 2nd?
Yeah, that's what let me see.
Yeah. Okay, we need to do his preliminary Monday. Okay, state can be ready. You know, there's not gonna be anything to do this weekend anyway. I can be ready for Monday because it's gonna snow. We'll be stuck at home.
Yeah, well, Your Honor, we're going to have to contact both of our witnesses, the officer and the victim, and make sure they can be here on Monday, but I would assume, I mean, if the court's going to set it then we'll try to be ready.
Well, I gotta set it within 10 days of his incarceration.
Yeah, that's fine. That's fine.
All right, so February 9th will be the preliminary hearing. 10 o'clock. Okay, that's all.
State of Ohio versus Ben Justice. It's number CRA 2673, CRA 2674.
That's my little girl, and this is from my sister.
That's a sibling, it sounds like that.
She's
got the pain in the office right now.
Yeah.
And I'll tell you when to call back.
I can't read her right.
I remember that. I remember you told me that at the arraignment. Yeah, the first time I saw you, when we did it on TV, I talked to you, that was me.
Your Honor, system, I have spoken back on this. I think he's in a psychiatric evaluation. I have been doctoring up one on a recent case we had for quite some time for the clerk to present to you. I just can't waive the hearing. I can't have the hearing at this point. I just can't.
Mr. Deal?
I'm sorry, could you repeat that?
Well, I'm moving for a psychiatric evaluation, competency evaluation.
That's fine.
I started working on it.
Just had one in North Carolina.
Just had one.
Okay.
Before I got here, got picked us up.
So Southeast Ohio Forensic,
Yes, that's what I had from the other one.
Anything video? I'd like to see that, because I got a lot of shit happening in your operation.
Okay. Mr. Smith can look at that.
Yes.
When do you want to come back?
Judge,
It's going to take.
I'm here any Friday in February, but not in March, I need March.
Okay.
Your Honor, can I say something, please?
No, sir.
That's my witness.
You can talk to the lawyers if you want, but you can't.
Okay, I would like to speak to him for just a second, please. Yes, sir, he's been in the hospital 3 times in North Carolina.
Case number is 2673, 2674.
He needs help. But he really needs to be in a hospital, not a jail.
Sir, I'm right there with you. I hear what you're saying. You need to go to the legislature and tell them to turn loose some money for mental health treatment. They don't want to spend any money in this state on mental health treatment. We are woefully inadequately funded for that.
Well, he's been in the hospital 3 times.
Okay, that's enough. You don't need to say anything else. I heard what you said. We're going to do the system. And we have to get him evaluated, but there's not much out there for people in his position.
I haven't even got to place my phone card, read my rights. Nobody read me anything knowing that I can't read the words.
I'm going to set his next hearing for February 20th.
And I'm on my lawyer.
This is your lawyer.
That's my free lawyer.
You can call anybody you want.
I haven't placed the phone card, been read my rights since then. I haven't been talked to in 4 days. I've been in that cell by myself.
I talked to you.
I talked to you for 2 seconds.
Yeah, that's all I'm taking about.
Yeah, have your lawyer give me a call, I'll talk to him. State of Ohio versus James Gray, the court, case number CRB 2644, A, B, and C, CRB 2643. What's going on?
The jail. The jail.
Well, I'm here in the court, this is beautiful, right? Yeah. What about felons? So we'll just clean it out today, you know, we'll draw my spirit for it. We're on any time, I'll shelf this, but we're getting to tell them. So thanks for being on help. All right, let's be telling felons.
Mr. Stratton, you need some time to talk with Mr. Gray? Okay, we'll recall.
State of Ohio versus White Storms, case number CRA 2663. Your Honor, I'm told that Boyd County was on their way to pick him up, and so they didn't bring him. Boyd County was on their way to pick him up, but not anybody.
Okay. Well, I'll enter an order to dismiss the case here, so if they don't pick him up today, he should be released.
They're picking him up when we're getting ready to.
Okay, so he's already gone from the jail? Yes. Okay, so the case here can be dismissed.
State of Ohio versus Marty Tolliver, case number CRA 25757.
So are you Marty Tolliver?
Yes.
You're being served with a copy of the charges filed against you. Charge, there's only one. 25757 is the case number, and it alleges that on November 27th of 2025 in Fayette Township, you did receive, retain, or dispose of property, being a cell phone, that belonged to another person, and that you had reason to know it was obtained by a theft offense. So the charge against you is receiving stolen property. It's a felony of the 5th degree. Maximum penalty is a year in jail. It's $2,500 fine. You understand the charge?
Yes.
Do you have the money to hire a lawyer?
No.
Do you have a job?
Not anymore.
You used to?
Yeah.
Where?
McGinnis. I was lead supervisor at McGinnis. That was done last.
Until you got arrested on this?
No.
Oh, okay. So when did you last work at McGinnis?
It's been 6 months ago.
Okay. So you have no monies
No.
now?
I have another job lined up, but I don't have it right now.
Okay. I'll appoint Mr. Stratton. I think he's in the back. In the back. So I'm appointing Mr. Stratton. He is here. He'll talk to you today. State's position on bond. You got a South Point address? I'm going to appoint you. This is Marty Tolliver. It's a F5 receiving stolen property. It's over a cell phone.
State's okay with an OR bond, Your Honor.
Okay, Mr. Tolliver, I'm going to let you out on your signature. Your promise to come to court. Will you promise me you're going to come to court? Okay. I'll let you sign a $2,000 signature bond. So that means as long as you come to court, you don't have to pay $2,000. If you don't come, then you got to pay $2,000 and you get a warrant. Yeah. So now we're going to talk about when to come back for the next hearing. When do you want to come back for the next hearing, Mr. Stratton? Since he's going to be out on bond.
It's up to the board.
Well, what's your availability?
I'll be over next week, Monday and Friday.
Well, I don't want to set it for Monday. I can set it for the 13th or the 20th.
13th is fine.
Okay, February 13th will be the next hearing. And he will be fingerprinted at the jail? Okay. Because I don't have it in the file. He needs to be fingerprinted before he's released. But he should be released on no arm warrant. And then you got to be here next Friday, 10 o'clock, right here at this court.
Mr. Stratton, are you ready for James Gray? I am. State of Ohio recalls James Gray.
So, Great Granny, you say you people read and or watch too many horror movies and stories. That's not true. We just watch a lot of Dungeon Court. Though I will say that the carpet is officially named Crimson, Shining Crimson, and the lighting is ripped straight from the set of Dr. Strangelove. So I'm not saying that Stanley Kubrick was not involved in the creation of this particular courtroom, but I'm not saying he wasn't involved either. Say on that. Okie dokie, friends. So let's do some overtime stuff now. So I've got a few stories to share, a couple of photos, and then I'm going to replay a piece of the pre-show, which I never do, but there was a very important public service announcement that I think everybody should benefit from, so we're going to share that at the end here. If you want to join me on stage and you're a channel member, that link has been posted in the Discord. I would love to chat with you, so feel free because you have that opportunity now. Okie dokie, let's do this. Go here, and let's go here. And I don't like the way that looks, so let's go here. There we go. All right, so we, over the course of the week, have been discussing this abduction of Savannah Guthrie's mother. Savannah Guthrie being the co-host of the Today Show. And I've been paying attention to this because this happened right here in the great state of Arizona. nowhere near where the bunker is, but still. But a couple of new pieces to the puzzle. A neighbor spotted mysterious white van before mother vanished from home. So apparently, she was last seen at her home around 9:30 Saturday night. I think we've talked about that before. But Brett McIntyre, who lives across the street from Nancy Guthrie, Nancy being Savannah's mother, told the New York Post he reported an unmarked van to police. He couldn't recall exactly when he saw the van, but he said it was recent. It was somewhere on that street. It was a white van, full size, with no printing on the sides. It was parked on the street. Normally, people that are coming to work on your home will have a company vehicle, or if they're independent, something written on it. From now on, when I'm going out and about, I'll have a paper and pen and record anything unusual, he added. So that's an interesting piece of the puzzle. But this, from last night, Harvey Levin appeared on Hannity. I don't particularly care about Hannity, or Harvey Levin for that matter, but he had some interesting information. TMZ founder Harvey Levin appeared Thursday night, provided explosive new information. Levin outlined that while an initial Thursday deadline for an alleged ransom note had passed, a second Monday deadline is far more consequential. Quote, the letter begins by saying she is safe but scared, and they go on to say she knows exactly what the demand is, Levin said. And so they are, through us telling the family, and obviously the sheriff's department gave the family the letter we received, exactly what they're demanding and what they're saying. Nancy is aware of it. Levin said the contents of the letter make him believe the individual who wrote it was nearby, possibly in the Tucson area. He said the individuals behind the note knew specific information about the placement of objects in Guthrie's house, including the placement of an Apple Watch, information he said was not publicly available. There's a phrase in this email that absolutely makes me believe this person who wrote this, and they're telling the truth, that Nancy is within the radius of the Tucson area, not in Tucson right now, but in a radius. Could be New Mexico. I don't know how far, but I think at least the authorities say they've got a radius, and that's something. My personal belief on this, to be honest with you, is that if she has been abducted, I would not be surprised if they're in Mexico. For as much as we talk about our border security, there are all sorts of ways to get across that border without anybody noticing. I remember, it's not near Tucson, but I remember several years ago being in El Paso, and there's a road there that's just open back and forth between El Paso and Juarez. There's no guards, no nothing, just people moving back and forth. And my belief was it was opened for commerce purposes because you've got workers and stuff going back and forth because those two cities are so integrated. But it's a thing, and I wouldn't be surprised if that's where she is. So we'll keep an eye on this story over the weekend, but I'm curious, obviously, to see what happens, and hopefully all turns out well, but I don't think there's a lot of doubt in my mind anymore that somebody has kidnapped her and is holding her for a bunch of money. And Savannah has a bunch of money, so would not surprise me. Anywho, two other court stories that are interesting that I wanted to share with you. This one was from a few days ago. I've been holding on to it, but hadn't had a chance to get to it yet. So this is from the 10th Circuit, and it has to do with a case in Kansas and how law enforcement is approaching things. But the 10th Circuit panel found that out-of-state motorists who sued Kansas over a traffic stop have standing, but a federal judge went too far in an injunction that imposed documentation and other requirements. At issue was a tactic used by Kansas Highway Patrol, where a state trooper turns away from the driver's door and then turns around and starts talking to the motorist again. This maneuver, sometimes known as the Kansas two-step, initiates what law enforcement describes as a voluntary interaction with the trooper, as opposed to the rest of the traffic stop, which is involuntary. So I don't see a need to go into the rest of the article, but I wanted to pull it up because it's super interesting to me in a bad way. But I'm glad that there's a court that's challenging this and allowing a challenge to go through. That the tactics of the police, at least there, have evolved to a point where they realize that if they disengage and then go back, it changes the dynamic. And at that point, anything that is said by the motorist would be considered voluntary information that was given. That's messed up. You know, I'm not the bash all police kind of person that we see out of so many. I mean, I get why some people do that, but I think we've gone over the top and there needs to be a meeting in the middle. Otherwise, you're just it's a snowball effect. You just create more of what you're trying to get rid of when you're constantly bashing it. But that's a messed up tactic. So I'm going to follow this story and see where it goes in the courts from here. But I'm glad it's being challenged because that's not right. You know, especially when you're pulled over, it's all involuntary. But the fact that they're using like this legal loophole to disengage and then re-engage to flip the script, so that at that point, conceivably anything they say could be used against them because it becomes voluntary at that point. That's a pretty messed up situation. There's that. And then one other story I wanted to share. This one just came up this morning for me. And this is disturbing for a different reason. Ninth Circuit takes aim at California gun dealer surveillance law. Ninth Circuit panel on Monday questioned the need for continuous audio surveillance of firearm transactions as required by California law to aid enforcement investigations. Gun dealers on the Second Amendment Foundation are aiming to revive their challenge to a part of California's penal code that forces licensed firearm dealers to maintain digital audio and video surveillance of the premises. They claim the statute violates the First, Fourth, and Fifth Amendment rights, saying surveillance amounts to a continuous warrantless search without probable cause. This is not a case whether the government may regulate a licensed entity. It's about whether the government may require private parties to carry out suspicionless government surveillance programs. The audio is troubling because I don't think you need that information, said Leah, Donald Trump appointee. There is a lot of core political speech, and it will have a chilling effect if they think the government can have a year's worth of everything you say. You will be deterred from saying things. Yeah. I got a big problem with that, you know, because I could see it being misused for sure. You know, gun shops, whether we like it or not, and it really doesn't matter what side you're on, they can often be a place where you're going to have political speech going on for sure, because you're either, you know, you might be getting a firearm because you believe this side is trouble or that side is trouble, whatever the case may be. But the idea that all of this information is being collected and it's just out there for the government to then go and grab at any point, that bothers me. Now, the good news for me anyways, that's in California. I'm in Arizona where it's illegal not to be armed at all times. And we don't have to register our firearms, and we don't need, it's constitutional carry here, so we don't need a concealed carry permit, all of these things. So we're very much 2A aligned here, where California obviously is not. But I would tend to see that as an overstep. So this will be yet another case that I will follow to see where it goes, because I don't like it. I don't like the idea at any time, no matter where you are, of the government just continuing to collect more and more of what you say and have it recorded. That having been said, the problem goes way beyond just a gun shop. I mean, it's everywhere. We have devices in our home recording us at all times. It's, you know, and we do it willingly. So go figure. All right. I want to share 2 pictures with you. And then I want to play you a PSA. and then we'll be done for the day. First off, we didn't see much Ellie until the end of the show. She's actually sleeping again. But this was Ellie at one point in her bed. I moved her bed down by my feet the other day because she just had this this need to be lying at my feet. So I put that down there. So that was her a little earlier. And then about 20 minutes later, she assumed this pose, which is just hilarious to me. The ways a cat can twist themselves is just absolutely amazing. I am going to attempt, if I can, this weekend, if I can find the time, to get an Ellie cam set up so we can keep a better eye on her during the show. One last thing for you. So I want to play a piece of a piece of the morning pre-show. And this is a public service announcement that I did, and I think it's a very important PSA. So please give it a listen, and then we'll call it a day afterwards. Every day, in homes just like yours, innocent popsicles are opened with love, only to be abandoned in beds across America. Some never even make it to the first lick. Last night, a popsicle in this home was just one of countless victims of nighttime popsicle neglect. Beth bravely requested a popsicle to help survive a hot flash. Me, doing the Lord's work, delivered. But within minutes, she drifted back to sleep, and that popsicle melted. Alone, afraid, soaking into her clothing one sticky tear at a time. But you can help right now. For just $0 a day, you can make a difference. Here's how you can join the fight against popsicle waste. Don't popsicle drowsy. If your eyes are closing, it's not snack time, it's nap time. Use the buddy system. If a loved one is eating a popsicle in bed, assign a responsible adult to stand by with a napkin, a towel, maybe even a shop vac. Adopt, don't neglect. When you open a popsicle, commit to seeing it through. Don't leave it to melt on a pillowcase wondering what it did wrong. Establish a popsicle safety zone. All popsicles must be consumed in the kitchen, sitting up, or at least 10 feet away from clean sheets. And finally, if you see something, say something. If you witness someone drifting off mid-bite, gently remove the popsicle and whisper, "Shh, you're safe now. I'll finish this for you." Together we can end the sticky. Right now, somewhere out there, a popsicle is sliding slowly down a fitted sheet. A pillow is absorbing cherry-flavored trauma. A spouse is waking up wondering why their arm smells like blue raspberry. But it doesn't have to be this way. Join us. Stand up. Say no more popsicles left behind. Until that day comes, please keep your freezers cold, your sheets dry, and your popsicles where they belong. Safely in your mouth, not glued to your shoulder blade at 3 a.m. This message has been brought to you by the SPCP, the Society for Prevention of Cruelty to Popsicles. There you go, ladies and gentlemen. Just an important PSA that I did share during the pre-show. I felt it would benefit everybody, so I wanted to make sure that everybody got the chance to see it. All right, ladies and gentlemen, that will conclude the festivities for this week. I hope you all had fun. I know I did. We will have best of shows for you this weekend, as well as some other videos posting. We'll be back live on this channel Monday morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. Do have yourselves a good weekend, and I hope to see you out there on the channel during the weekend and interact with you where I can. But do have yourselves a great weekend. Take care. God bless.